చెక్.
ఓకే.
మైక్ టెస్టింగ్. ఇది కాలర్ మైక్ది
रुकिए तो let them start. A very good morning to everyone present here. A very pleasant morning to all the attendees as well. I am Reed Balmiki and I will be moderating this session. I welcome you all to the third and the final day of the National Conference on Developments and Trends in Corporate Laws and Governance. As we commence the concluding day, we anticipate a culmination of insightful discussions, profound presentations, and invaluable learnings for all of us. After our enriching discussions during the first 2 days, we now reconvene for the fourth and the final technical session of the National Conference. In this session, the panel addresses and the paper presentations shall focus on an invaluable theme, that is the alternate dispute resolution mechanisms. As a part of our discussions, we shall also be covering the emerging trends in India in arbitration, mediation, and conciliation, the growing role of international commercial arbitration in India in various sectors and industries, the developing laws surrounding mediation laws in India, and the legal impact of ADR on corporate functioning and growth. Without any delay, I would now like to welcome our esteemed chairperson and panelists to the dais. I begin by inviting CS Dr. Bhaskara Mohan sir to the dais. Sir is the chairperson for the session. Sir, I please request you to step on the dais for us. I also request CS Rakesh Sharma sir from Delhi to please honor sir with a sampling. Dr. P. Bhaskar Mohan sir is a former judicial member and the head of the Department of Jaipur Bench of NCLT. Sir is presently practicing as an advocate of the High Court for the state of Telangana and also acting as an arbitrator and conciliator. Sir has also served for the Government of India as an additional central government standing counsel in the erstwhile High Court of Andhra Pradesh. Sir was associated with the International Center for Alternate Dispute Resolution in collaboration with Nalsar University of Law as a founding faculty member since the year 2000. Sir is also the chief editor of Arbitration Handbook published by ICSI during January 2022. Thank you so much for gracing our event, sir. Thank you for being here with us. Thank you so much. I would now like to invite Dr. Sridhar Mote, sir, the chairperson for Indian Institute of Technical Arbitration, APN Telangana, Hyderabad. Sir, please join us at the dais. I'd also request CS Totadurga ma'am from Chennai to please honor sir with a sapling. Dr. Sridhar Mote sir is currently the principal consultant of Mote Associates, a contract management consulting sir. Sir was with NCC Limited heading contracts and claims and of building division. Sir has also authored a book titled Infrastructure Contracts and Management, published by Asia Law House, and has been awarded the Engineer of the Year 2020 award by the Telangana government. Sir has also received Vishwakarma Award for 2023 by Construction Industry Development Council for contributing in construction education and training. Thank you so much for being here with us, sir, today. Next, I would like to invite Dr. Sarva Reddy Pradeep Reddy, sir, the Secretary for the Indian Institute of Technical Arbitrators, AP and Telangana, Hyderabad. I also request CS Rajesh Agarwal, sir, from Bangalore to please present, sir, with a sapling. Dr. Pradeep Reddy sir has a LLB honors degree, a master's degree from USA, and a PhD as well. Sir has about 25 years of experience and a vast experience in various contracts, arbitration, company law, corporate law, and taxation. Sir handles arbitration matters of all kinds, both as a counsel and as an advisor, and advises clients on corporate matters, including structuring of a company, partnership contracts, joint venture agreements, and so on. Sir is also well versed with technology, including various aspects of cyber law and cybersecurity. Thank you for being here with us today, sir. We are looking forward to hearing from you. I would I would now like to invite CS Chivukula Vasudev sir, the CFO of Ramki Infrastructure Limited. I also request CS Abhinav sir to please honor sir with a sapling. CS Vasudev sir has previously worked with L&T Geostructure as a CFO, Joint General Manager, and Head Finance, Accounts and Administration. Sir brings with him 34 years of rich and diversified experience across industries. Sir is a fellow cost and management accountant of the Institute of Costs and Management Accountants of India, ICMAI, and associate company secretary member of Institute of Company Secretaries of India. Sir is a management professional with an expertise in areas of strategic finance, business sustenance, project finance, EPC, PPP in metro rail and airports mega projects. Thank you so much for being here with us, sir. We are honored to have you here. With this, I would now like to invite Dr. P. Bhaskara Mohan, sir, the chairperson for this session, to please address the gathering.
Very, very good morning, my dear friends. Sridhar Moteji and then Mr. Pradeep Reddy. They are the stalwarts of the Indian Institution of Technical Arbitrators and the panelists here, and then Mr. Chukala Vasudevji and all my learned friends, my colleagues of Institute of Company Secretaries of India. Incidentally, I am also a fellow member of ICSI, even though I'm a lawyer practicing. And then my fraternity of law and my fraternity of teachers. I got 3 alma maters, the University, Usmania Postgraduate College and the law faculty, and then the Institute of Company Secretaries, and then my legal fraternity. All the 3, in their lap I grown. So I'm grateful to all the 3, in fact, and all the colleagues here are there. So that is a great pleasure for me that even though I know very little, they are kind enough to call me here and then share a little of my thoughts over this particular subject matter. And then quickly I will come to the subject because time is running out. We will have to close down at any rate by 11:45 because there are high dignitaries coming up. We'll have to receive them. So we'll have to do that. So the time constraint, professionally we will manage. Professional management of time. And before that, I had to convey that I got a very long association with Nalsar Law University from 2000. And I had the opportunity to be the founding faculty of Nalsar and ICADR combination, running a course for 15 years, 10 months in a year, 150 months. And then I had the opportunity to train the students for 10 months on theory and practice of arbitration, domestic as well as international commercial. So that was a great learning for me. I don't say I trained students, I trained myself and then I got improved myself and learned a lot, updated myself with case law and the theory and the practice, of course. With that, I became also an arbitrator. So utilizing that experience, utilizing my experience as arbitrator in the teaching. That is how I'm grateful to God and all the alma maters. Let us quickly now come to the subject matter. Friends, ADR is the need of the hour. In fact, the slogan could be, it is conciliation but not confrontation in law now. For the reason that 10 years in civil courts, the matters are pending, and another 10 years in high courts, and another 10 years in Supreme Court. Ultimately, no advocate will survive by the time who started the litigation, nor the clients. and all the legal heirs, including the judges, will have to meet in the Supreme Court. That is why, in fact, ADR, in fact, has gained a very, very importance and then practical significance in foreign countries. India is also now, in fact, updated. And I can say in the present day situation, we are raising to such a level, there is no match to us. That kind of training, that kind of knowledge, dissemination of knowledge now going on. For example, the Institute of Company Secretaries started the training program. Nalsar is doing well, of course. 2000, I have been the founding faculty. I think the Institution of Technical Arbitrators, two great stalwarts are here, Mr. Mot Sridhar and then Mr. Pradeep. They are doing really a great job. I attended several of their programs and they are concentrating on technical. ICSI is concentrating on all, it is all in all techno-commercial. So Madam is here, the chairperson of the Institute of Company Secretaries Hyderabad chapter. And then our COE Center, Center of Excellence, has taken up a very rigorous training programs on arbitration. Actually, friends, the issue comes like this. Prima facie, we go to the courts of law for dispute resolution. But the question comes as to, suppose the matters are pending like this and then they are not resolved on time, then how do we handle this particular situation? Is there any remedy, alternative? I don't say substitute, alternative, so that this problem could be solved. What people want, the public, the disputants want, before their end reaches them, the ends of justice should reach them. This is the primary objective. Otherwise, legal hates, it is unfortunately, I had to file 3 legal hate petitions in a period of 15 years. Father and then the other representatives and the other LRs. So a question comes as to how do we handle this? How do we come out of this? So actually, I was looking into the history. 1 minute I will tell you. It goes back to 1781. This problem cropped up at that stage itself, and the British Crown regulations were issued for arbitration by East India Company. And subsequently, it was improved in 1787. Then the governor of Bombay issued proceedings, and arbitration was introduced at that point of time, that is taking away from the courts the dispute resolution process and giving the adjudication process to the private persons. Then that was brought into CPC. And then finally it was put into the 1940 Arbitration Act, and it was further improved in 1996 Arbitration and Conciliation Act. This is the history. That means alternative dispute resolution was searched, and it was found to be better for various issues, especially 1781. All courts were filled with the national movement, and then people mostly facing criminal charges. So civil matters were diverted, and the value was 200 rupees at that point of time. Today it is 20 crores. I'm talking of 1781. So this particular concept of arbitration at that point of time was mooted, and then that was put into practice. And subsequently, other issues like I find America and London far better with regard to mediation. Conciliation was not there. There is a difference between mediation and conciliation. I will quickly make out the points there. So prima facie, the mediation was taken in order to make out a proper dispute resolution with a legal sanctity, so that that would be equal to decree of courts of law. So what happens is, whatever is done in mediation, whether inside the court or outside the court, would be taken for granted. Dispute is closed there, no further appeals. This is a beautiful concept. Of course, we have also developed this subsequent to arbitration. Now I have already given the history. The second issue comes into courts, out of court settlement, passing compromise decrease. So that no Supreme Court, no High Court. If you challenge it, it is contempt of court. People will go to jail. It has been there right from the beginning, even 1908 CPC, even prior to that. That is the second aspect. Now the third point, Section 89 CPC, I feel before that I should tell you about the Legal Services Authorities Act 1986. That has given real light to the people and real relief to the disputants, wherein you must appreciate the Legal Services Authorities Act 1987, I'm sorry, has created Lok Adalat system. This Lok Adalat system as ADR mechanism mooted for mutual settlement of disputes headed by the law officers, headed by the judges. So the bench and bar came together and they started clearing of the disputes. My first experience in 1990, I was a student of LLM, practicing lawyer. I remember the great Professor Manohar Rao, he is no more, late professor. Under his aegis as principal of PG College of Law, we all organized with the Legal Service Authority a mega Lok Adalat. That day, accident cases, 50,000 cases were disposed. Crores of rupees checks were distributed. And some of the widows came to us and said, I never expected in my lifetime to receive compensation for my husband's demise, run over by a lorry. Today you are here, and she was in tears. So that was in fact, our institutions, academic institutions took the lead. And then they have become part and parcel of judicial system. That is where the classroom and courtroom came one. The gap between classroom and courtroom, as a teacher, I thought should be narrowed. That is what the endeavor I did. I don't know how far I am successful, but certainly I made an endeavor. And this was the result of that. So Lok Adalat system played such a mega role. Today, friends, we have got Lok Adalats all over India, right from Supreme Court to the lowest court in the country. There are regular Lok Adalats, permanent Lok Adalats, and national mega Lok Adalats. And they're today disposing lakhs and lakhs of cases. Only thing, you watch out the information in the newspapers, you will understand. Some of the students of Nalsar are here. You please do research on this particular dispute resolution with Lok Adalats. And you impartially write. If there is a defect, you write it. If there is in fact, achievement, you point out. This is very essential, in fact, in order to bring out what is happening. The judiciary is not silent. For democracy, backbone is judiciary. And it is playing a very pivotal role, effective role, and then I can say excellent role. Otherwise, our democracy with 140 crores population could not have been protected. That is the reason why judiciary is the backbone of Indian democracy. So, my dear friends, now the new development came in 2002, wherein we have crossed the arbitration, we have crossed out-of-court settlements, we have crossed the Lok Adalat system, and now a more crystallized and scientific, professionally managed system has been introduced under Section 89 of Code of Civil Procedure, wherein it speaks of reference indulgence by the courts. What exactly happened? The High Court of Andhra Pradesh at that time introduced a training program on 89 CPC from 2006 to 2015 with ICADR. God is so kind. I happen to be one of the faculty because I learned a lot. I don't say I taught a lot. I learned a lot. Running around entire Telangana, Andhra Pradesh, telling the learned judges, you have to indulge yourself in this process. Then what is 89 CPC? 89 CPC speaks of, there are 5 elements which can be taken out. One is out-of-court settlement. The other one is judicial settlement, where there won't be any appeals. followed by the Lok Adalat system. Lok Adalat system, I already explained, that would be making out decrees, no further High Court, Supreme Court and all that, no problem. Next, 3, 4, 5, indulgence of third parties into the dispute resolution. First 2, court involvement. 3, 4, 5, private parties. Who are the third persons? We are all. Any educated man, age of majority, having brain. We remember Olive's story in our non-tail text in our childhood. The king found one 10-year-old boy giving a judgment on olives. And he said, he is the right person to decide. He is supposed to be a good judge. The same thing happened with third persons being trained. What Section 89 CPC says? There could be mediation, conciliation, and arbitration with indulgence of third parties. Judiciary will not interfere. What is that indulgence? Every court today, from Supreme Court to lowest court in the country, has got mediation centers. And who are empaneled in the mediation centers? The retired judges, advocates, engineers, technicians, psychologists, psychiatrists. I got the experience of using them also. Psychologists and psychiatrists in resolving family disputes. They have been successful. And many divorce cases could be prevented because of that indulgence. And the Telangana and Andhra Pradesh civil rules of practice amended to include company secretaries also as the members to resolve these disputes. That is our greatness. They said, you give, because we have got grip on law. I am a better lawyer because of my background as company secretary. And the support given by Institute of Company Secretaries members to grow as a corporate lawyer. I am grateful to them. Openly, I am saying this. That is the reason why chartered accountants, company secretaries, cost accountants, they are all third parties indulging in mediation, commercial disputes, lakhs of rupees, company law matters, some of them, oppression, mismanagement, mediation centers. Our company secretaries can do that. Technical accounting, chartered accountants, corporate disputes with regard to costing, cost accountants, regular matrimonial matters, lawyers, regular commercial and techno-commercial lawyers, retired judges. This is how the mediation process is going on in India now. Now, what is conciliation? It is something very beautiful. If a conciliator is appointed, whoever he may be, even teachers, I in fact support the teachers also being trained to become this particular third parties, wherein these particular teachers, I mean anybody, resolve the dispute. They take the signatures of both the parties on the agreement with stamp paper. This third person signs as conciliator. It is a decree of court of law. You don't have to get stamped. You don't have to go to court of law. You don't go to High Court, Supreme Court, anywhere. This piece is a decree of court. Once for all, the matter is closed. How beautiful it is. I will come back to you. Now, the last part is arbitration. What is this particular arbitration? Now, before that, the Mediation Act 2023 has shifted the provisions under 61 to 81 of the Arbitration and Conciliation Act to Mediation Act. And then they made some changes. Well, there would be panel discussions and all that. On that, how the Mediation Act is effective. All question and answer session, we will travel till 11:45. So all these things we can handle. So I don't want to take much of the time. Another 5-10 minutes, I want to close down. I will answer your question and go. So what happens here? This Mediation Act now specialized in conciliation. Mediation, conciliation are one and the same today in India. Mediation and conciliation are one and the same in the entire world. I say with authority. There is no separate conciliation in foreign countries, even though UN has formed the rules now. So today, mediation, conciliation are taken on one footing by the Mediation Act 2023. Now come to arbitration. I had to travel for 5 minutes on arbitration. Then I will hand over the match to my panelists. I hope you excuse me for 5 minutes, sir. So what is this arbitration? Number one, first question. It is third party adjudication. What is adjudication? It is not mediation. It is not conciliation. It is not lok adalat. It is not out of court settlement. It is deciding on rights and liabilities of the parties like a judge. If that is the case, why should I go to a third person? He may be a teacher and he may be an engineer, he may be a lawyer, we don't know. But there is a court of law. The reason is, in courts, proceedings are formal. Before arbitrator, proceedings are informal. In courts, I'll have to take 10 years for deciding the matter. In arbitration, in one matter, I got, in fact, I myself happen to be an arbitrator, an award for 21 crores online, I cleared in 3 months. I never, possible. It is possible. Nothing is impossible. It may be difficult. In my childhood, I learned from my father, you may say it is difficult, but not impossible. Nothing is impossible. We can make it. So that is the advantage. Second point, if it is international commercial arbitration, the award is executable globally. Whereas a foreign court gives a judgment in my favor and the properties are in Hyderabad, that foreign judgment is useless for me. I can't attach any of the properties. If my Indian court gives me an order in my favor for 1 lakh crores, I had to execute that in the United States. I can't do that. Unless there is a protocol and then permutations, combinations, according to my knowledge and research. I may be wrong. At the moment, it is not available. What I had to do is get the foreign decree to India, and under CPC, I had to put a retrial. Then I had to get a decree from Indian court. Before that, this guy, I had to ensure should not transfer his properties and then go to US. And then attach the properties and then get my money. By the time I don't know I will be alive or not. This is the problem. But in arbitration, international commercial arbitration, take place in India, execute, enforce your award outside, no problem. So this is because of the unilateral model law, which has been adopted globally, and this is binding on all signatories, all countries. This is the best advantage we get in arbitration. So one more aspect is arbitration, prima facie, can take place at any point of time. So one arbitration, one learned justice told me, I had to leave for states, will you cooperate? I said, well, sir. Then every day evening after court hours from 6 to 11, I used to attend his arbitration. Then after 1 week, he said, I am dictating judgment. So I said, fine, thank you very much, sir. And then he went on from 6 o'clock to 1 o'clock. Judgment was, award was clear. He said, tomorrow you correct papers. Fine, sir, thank you. I went home at 2:30. So my wife opened the door and said, kya ho raha bhai? I said, night arbitration. He said, night by arbitration chalega? Haan, bhai. She said, pehle to so jao. She's really a goddess for me. And then very understanding wife. So then next day morning, she asked me, night arbitration kya hai bhai? So I explained her. Then I got the award the next day. Remember, my dear friends, this gentleman left for state the following day, and unfortunately he passed away. Had it happened in regular court of law, a judge is transferred, judge is replaced, died, resigned, on leave, matter will be reopened. I had to again argue and argue. One matter I argued before 6 judges. Reopened 6 times in High Court. This is my 38th year of practice in High Court. I'm bearing my judgeship in NCLT. So this kind of catastrophe won't be there, especially in institutional arbitration. ICSI now has already started the arbitration center. So the arbitration center panels become the arbitrators. Nothing, in fact, to fear about. If anything happens, it will continue where it stopped. Again, fees need not be paid afresh. All these advantages are there in this institutional arbitration. Ad hoc also we can ensure, and then we can take care of. So these are all the best advantages we get. And the last part of the discussion is the arbitration is also on par with courts of law, but not the traditional way. CPC, Evidence Act won't apply. Only Section 19, how to arbitrate, how to proceed, and the provisions from Section 18 to 33 tell you meticulously what you have to do, what you should not do. You read thoroughly the entire Arbitration Act, you will understand every important aspect. You can become definitely good arbitrators. You are all highly qualified people. So there is no difficulty for you to understand it. The last part is, in fact, there is a goddess of justice, which is blindfold. Always I convey this. She's blindfold does not mean court has ears but not eyes. Court has third eye. In Supreme Court, goddess of justice figure is there, meaning is not there. So I went in search of the meaning. I got it. And right from ICADR programs, Nalsar ICADR programs, our ICSA programs, I have been distributing over 10,000 copies I distributed till now. It says that you must not have dog and serpent relationship. What is dog and serpent? Dog is for friendship. Serpent is for hatred. A judge should not have both. He must be balanced. Only then justice system will survive. Otherwise, justice system will die. I close down with only one very small example in a half minute. I fought a very severe, important case against a senior lawyer, and that particular lawyer won the case. I suggested for Supreme Court. I went back. 20 days later, a letter has come. Some parties wanted to appoint me as an arbitrator. I said, fine. Sole arbitration. I gave notice. In the notice, after other date, the parties came along with lawyers. And one of the lawyers is this lawyer who won the case against me. Now, dog and serpent relationship. No hatred, no friendship. This is a matter of hatred. I lost, and very heavy matter. So I disclosed. This is the situation. And probably I recuse. I will not handle this. In writing, parties given, we accept your arbitration, please go ahead. I continued. Then I heard both the arguments. After 1 month, I delivered the award in favor of the one who won the case against me. That is dog and serpent relationship. So you want to become a good arbitrator, follow the goddess of justice. And then now I am wrapping up. Thank you very much. And then I will now go with the panelists. Maybe excuse me, I might have extended a little time, but please go ahead. And bahut dhanyawad sabko. Thank you very much.
Thank you so much for your insightful words, sir. I now invite Dr. Sridhar Mote, sir, to address the gathering.
Respected my Guru, Dr. Bhaskar Mohan Garu, Vasudeva Garu, and Ms. I'm happy to be here. It's just like a homecoming because I was a student of Nalsar, you can say alumni. We did 2009 the course, ADR course referred by Dr. Bhaskar Mohan. We were the first batch of students there, and we learned the arbitration from him. I privileged to call him my guru. Being an infrastructure industry, we felt that we have to know certain ADR methods, and we did the course. Later on, I did law also, PhD in contract management, but the source of that seeds of arbitration fundamentals, what he has taught, even this day I remember a lot. We are grateful to him. And as he rightly said, so many things. After a guru speaks, nothing much is left for the disciples to talk. Well, also, I'm happy that I have been a practitioner from infrastructure industry practicing this arbitration, and there are a lot of cases, all sorts of conciliation, not mediation. And I have been teaching this as a subject in so many training and teaching institutes, more than half a dozen institutes. ICSE also, I have been a visiting faculty, and also for Nalsar trainings, I started as a visiting faculty from last time. So basically, we are from the infrastructure construction industry. If you see the construction industry, I will not take much of time, just 5 minutes. Construction industry, as we all know, this is contributing around 9% to the GDP. After agriculture, this is the second employment generation. Agriculture provides around 10 crores of families livelihood, and construction industry provides livelihood for around 3.5 crores of people. But it is an irony to say that construction industry is also one of the support of the litigants, means around 1 lakh crores of cases are pending in arbitrations, courts, DRPs, and conciliations. In a way, this is very alarming. In a jovial way, that is the biggest supporter for the litigants, means the persons doing practice as lawyers, consultants, also arbitrators. That is only a jovial part. But if you see the arbitration practice going on, arbitration is supposed to be the speedy and cost-effective dispute resolution process. But the way now the things are going on, even despite the 29A, much time is cases are being dragged. And the basic spirit of arbitration is getting just diluted. That is a very irony. Of course, conciliation was not much practiced because of this Mediation Act. There is a lot of good uh, spurt in the policy from the government is there. So that hope that this alternative dispute result. What is an alternative? Alternative to court. If you go to the court, more than 3 to 4 crores of cases are pending in various courts. If you go to the courts, even for your corporate sector disputes also, it is going to take a much amount of time and also energy procedure. Alternative is a participative and with less time, and persons can resolve their disputes, your commercial disputes also. Policy framework is good. Recent Mediation Act has also been enacted. But basically, for dispute resolution, what I feel is our mindset should change. There is a policy, there is a regulation. Why do you need a mediator to just facilitate your talk? Why do you need a conciliator who will assist you so that you can arrive at a settlement? If you see 9 or 10, we also teach in your ICSE what are the ADRs and arbitrations. Last thing we deal is negotiations as a 9th or 10th alternative dispute resolution. But there is a first and fundamental foremost dispute resolution. Talk directly, negotiate so that your disputes will be settled. What I want to say is ADRs is a very, very first and the foremost good alternative dispute resolution mechanism, alternative to courts. But to encourage and to propagate this properly, first, we have to change the litigant parties have to change their mindsets. First, you indulge in your talks, negotiations, try to resolve mutually, probably in commercial disputes also. In family disputes also, this is a buzzword because as Sir has rightly been pointing out, Lok Adalas and mediation, particularly in family disputes, is having a very good positive results. With this, I would like to congratulate all of you for coming forward in making this thing. Thank you very much. Thank you.
Thank you so much, sir. I now invite Dr. Sarvareddy Pradeep Reddy, sir, to address the gathering.
So once upon a time, there were 4 people in a room. Let's call them Dr. B, Dr. S, Dr. P, and CSV. So the person asked, what is 2 plus 2? Dr. B is very straightforward. He said, it's very simple. My dear friends, it's 4. And then they asked Dr. S. Now, Dr. S is a little bit more technical oriented. So Dr. S looked at his calculator, looked at some of the books, and said, well, it has to be 4. But even if you consider all the statistical analysis with a variance of plus or 5, minus 5, and a confidence interval of 95%, he said it could be 4.0. So they asked CSV, what is the answer? So CSV took and said, let's consider all the credits and the debits. Let's also see the deemed expenditure and accrued income. It has to be 4. So they asked Dr. P, what is it? What is 2 plus 2? Dr. P said, let's close the doors, and said, what do you want it to be? So I'm a little bit of a bad boy. So when Nalsar invited me to this event, I said, what else can I talk after our learned gurus here have spoken? Well, I said, there is something different. They are all good boys. I, on the other hand, a little bit bad. So I said, let's talk about the bad. And chose this topic, insider view. Insider trading, it's not favorite. Rumors or gossip, again, not a suitable word. So I said, let's make it a little bit professional and called it insider views. So what is the judgment ultimately? Don't worry what others say. They are telling you their story. 2 plus 2 was 4 yesterday or a minute ago. Now I can prove it. What do you want it to be? I can show it to you. So don't listen to others. Believe in yourself and you'll be able to do it. So when you're looking at arbitration, you think everything is smooth. It's not. That's your plan. But the reality is going to be much more worse than a ride that you have ever taken. Okay? Now, what are the types of arbitration? Broadly, we can say there are 3 types: institutional, ad hoc, and statutory. Broadly, again, multiple permutations, combinations exist. So let me slow down here and say, what is arbitration in the first part? As our seniors earlier have spoken, arbitration, if I were to simplify it and say it is nothing but a private court. So you can choose your arbitrator. So I could be your arbitrator, and with all respect, your peon here can be an arbitrator. Your watchman, security guard can be an arbitrator. As of now, there is no qualification for an arbitrator. But for a good arbitrator, there has to be a qualification that we'll talk later. So arbitration is nothing but a private court. What is institutional arbitration? Now, again, once again, slow down. Arbitration is not negotiation. You cannot come here and argue with me. I'm just a judge. Just like a court, let both the advocates or counsels or the parties present their case or argue among themselves, and I will give a judgment, and I'm going to sign it. I alone am going to sign it. If we are 3 of us, we 3 will sign, or at least the majority, the 2 of us will sign. That is binding. You cannot come back to me and negotiate. Just like you don't negotiate with a court. Anytime you get a doubt as to what is arbitration, think about a court. What happens in a court? Something similar. Of course, as sir has said, we can have night arbitrations, we can have Sunday arbitrations. In fact, all my people where I live, they see me wearing a suit and boot and leaving my house on Saturday and Sunday morning. By 9 o'clock, I'm out. On weekdays, relaxed. So that is arbitration, the flexibility there. But in all other aspects, consider a court, then you'll get a lot of answers. So what is institutional arbitration? Just like ICSI is taking up institutional arbitration, which means ICSI will facilitate a lot of things. There is good, there is bad. Everywhere, wherever there is good, there is bad. So we'll see that also. And what about ad hoc arbitration? Ad hoc arbitration is you're passing on the street and I'm saying, I'm an arbitrator, arbitrator, come on, come on, come on. And you choose me. Literally, I'm selling myself. So you get to pick me, or you get to pick somebody else, or you get to pick a good person. Okay? So it's your choice. And the other person has to accept. If there are 3 arbitrators, you pick yours, the other guy will pick theirs, the 2 arbitrators will pick the third deciding arbitrator. So 3 members can be formed, or a sole member can be formed. Or if you have the resources, get 101 arbitrators. It's your choice, right? It has to be an odd number. That's the only criteria. So with 101 arbitrators, fill up this hall and we can present everything. Of course, the fees, that's a different story. So having said that, in ad hoc arbitration, you, the parties, and I, the arbitrator, we get to choose where we want to do, what we want to do, how we want to do. Okay, let's have one sitting in Switzerland. I have never seen Switzerland. Let's have the second sitting in, where do you want to be? Alaska. Let's go there. The third hearing we can have in Singapore. Right? That is the flexibility of arbitration. Ad hoc arbitration. Because the institution also allows some flexibility, but they would not allow me to go to Switzerland. Now, statutory arbitration is much more formal. It's much more defined. Or is it? We'll see. Institutional arbitration. Of course, ICSI is pushing for it. So I'm not going to talk all bad. I'm also going to talk a little bit of good over there. Now, there's a standard procedure for arbitration. Really, we'll see the procedures when we get to that. Certainty in the fees and cost. To that extent, I'll accept a little bit. But if you look at your Arbitration Conciliation Act, it has a fee schedule, a model fee schedule from the year 2015. Even if you hire somebody on the road, you pay him the same amount of fees. Even if you select a retired Supreme Court judge, you pay the same amount of fee. And that amount has not been inflated or adjusted for any of our inflation factors here. How is that valid even today after 9 years? Okay. So arbitral institutions for that regard are better because they keep updating more frequently than the acts. So some of the good parts, but there is certainty in the fees. And then of course, more confidence in potential ability of the arbitrators. Really. Now this is one point which I am going to fight. We'll get to that. Avoiding long time for appointment. Maybe or maybe not so. Because after an institute appoints an arbitrator, currently, the scheme of things, I am using the word currently, which is very important, because that is important for me to change it to what do you want it to be is based on currently. So the current scheme of things, I can go to court and challenge the appointment of the arbitrator by the institute. I can do all kinds of dialectic tactics and other tactics. But having said all these things, there is emergency arbitration, fast track arbitration, or something which any court cannot even visualize. This morning, we can get an arbitrator. By this evening, we can get the award and leave. That is the flexibility in arbitration. If there's an emergency matter, that can be handled immediately, instantly, like that, if both parties cooperate. That is the beauty of it. And then there's a review of arbitral award. Again, review is not rewriting the arbitral award because only the arbitrator has the power to write it. But the institute will at least give it a glance. We'll say, okay, these are some typographical errors. These are some issues which we are not clear. There are some arithmetical errors, kindly correct them. So these are the type of value-added benefits which an institute can bring. So for that reason, I am pro-institutional arbitration. Now, many people always say that they have secretarial assistants and all that, even institutes. But not everybody is so professionally trained. That is where some good institutes stand out. So that is we don't have to keep searching for a stenographer. You don't have to search for some facility where we can sit and talk. And the facilities, pretty much everything is provided for. Another biggest problem is this arbitration being everything. I, as an arbitrator, even have to do secretarial job. I have to call the parties, or the parties have to call me in deciding the dates. And these are ex-parte communication happening with me. Even though it is not really a technical ex-parte, it is supposedly, there is no other option for me. But when you have an institute, all the ex-parties communication is cut off. I don't get to hear anything from the parties, except the case, of course. Now, there are certain gaps that are missing in the Act. And on those aspects, institutional arbitration will help us out. So this sounds so good, so nice. But now let's see the other side, the dark side of institutional arbitration. Yes. So we say that arbitration, they have a lot of knowledge, even though they have passed an exam, like institutional empaneled arbitrators. Not necessarily. I have seen arbitrators who have argued with me saying that arbitration is a fact-finding committee. Of course, nobody asked me to repay the cost of the wall. I mean, the wall which I was hanging my head against after that. So nobody asked me for the cost. But that is the type of arbitrators we have in the market. Again, with all due respect, please keep in mind, there are very few great arbitrators. And I'm not talking about them, but I'm talking of the vast majority who claim to be arbitrators, who think they know everything, but nothing like that is there. So just because they're empaneled in 100 institutes doesn't mean anything if they don't understand the basics. And they may not be always fully aware of all your rules. They may be acting differently. Now let's say, what is Arbitration Act? Is it a substantial law or is it procedural law? Okay, let's even step back for all the non-advocates. What is the difference between substantial law and procedural law? For example, if you catch somebody stealing something, a thief, how do you punish him? Under IPC section 420. Of course, now it's being replaced. So 420 is a section under which you punish him. That is the substantial law. What is the procedural law? That is the Criminal Procedure Code. Of course, the title itself has it. So there is a procedure for arresting him, for presenting him in the court, for all the process to be taken care of. So that is a procedure. Now, what is arbitration? Is it procedural or is it substantial? Well, it's a combination of both. There is certain substantial portion, there's certain procedural portion. It's a combination. Now, what happens is your institute is rewriting the procedural aspects and codifying the procedures, because Arbitration Act does not have all the procedures in it. So those procedures I may not be aware of. Okay, I know the procedures of that institute, but not this institute. And these rules which I am adopting may not be correct, and my award can be challenged on that. So that is the biggest problem. Right now we have too many standards by different institutes. That is the biggest problem with institutional rules. Why would I agree to your code? My institute is better than yours. When did you become an institute? Just yesterday. I'm an institute with having 100 years of reputation. My ego is bigger than your ego. I will not adopt your rules. Yes, that is the future which we can envisage. Right now, like all the power adapters are having the same standard. All the cell phones are supposed to have only the C-type chargers. These are standards which have developed after we have polluted our planet. So we have not yet polluted the arbitral institutions. Let's wait until the pollution is complete. Once the damage is done, we'll talk about bandages and then how to make it pollution-free. But as of now, that's what we are there. And the institutional rules, we see a lot of time, they are not up to date. So that is another problem. The biggest problem is if the institutional rules conflict with the act, which will prevail? Why? See, is all about parties' consent. If the parties, both the parties agree, because most of the time the Arbitration Act has a non-obstinate clause. And so that can prevail over your rules or everything else. Now, Act has been interpreted by court, and the courts have said 2 + 2 is 5. I know that if I go that route, the court have said it to be 5. Fine, I know what to do. But your institutional rules have not yet been subject to the court scrutiny. They have not withstood the test of time. A known devil is better than an unknown friend. Your rules are better, my friends. But I don't know your rules. You are an unknown friend. It's uncharted territory in the legal segment. So I will go with the court rules, which the court accepts to be correct. So these are certain pitfalls. And we talked about the procedures, how institutional procedures are sometimes overwritten by the contractual provisions, or contractual provisions are overwritten by the procedures. Which will prevail? Again, these are things which we can keep on fighting about. Now, today I have adopted your institute because I liked your rules. But by the time my dispute occurs, which is 3 more years later, you have changed your rules. So which rule should I adopt? I don't like your rules anymore, but I'm already stuck because I'm married to your rules. Unless otherwise agreed by parties. But parties after a dispute are not going to be friendly anymore. Now, some of the institutes are taking decisions. The arbitrator is the one who's supposed to take the decisions. But I see that is not happening in the institutes. So kind of pitfalls. Biggest problem I see is the typographical error in the name of the parties in the institution agreement. So the appointing authority is wrongly mentioned as the president of the institute. There's no president for the institute, there's only chairman. The president could be all India level, but that's missing. So these are the kind of mistakes which we see happening all the time. And ad hoc arbitration, we have lots of dilemmas. Should we balance the time, the cost, or the quality of the arbitrators? It's always a balance. Now, how many of you feel that one arbitrator is better versus 3 arbitrators? One arbitrator. Okay, so I think most of the people think 3 arbitrators are better. A friend of mine said the same thing, that 3 arbitrators, it is difficult to bribe everybody. It's too costly. But I was recently faced with a situation where the 3 arbitrators were going with three different dimensions. One said he's not going to give the claim at all. The second arbitrator said he's going to give let's pick a number and say 1 crore. The third arbitrator said he's going to give a claim for 3 crores. Which will prevail? It's a 3-way, unclear arbitral award. Statutory arbitrations, we are all familiar with MSME, Facilitation Council. That's a topic for another day. Section 89, we just talked about. But in all, there are about 42 statutory arbitrations, 42. So human element, we've already touched upon some of these things. People are people. Let's just leave it there. Most people are scared of the unknown. That is, if they don't know the subject, they're afraid of the courts. The act itself is not perfect. There are a lot of mistakes in the acts. I'll not go through all these things, but I've been warned about the time. So one definition in the act that is confusing is, when does the arbitration start? Is the date the arbitral tribunal enters upon reference, or the date the arbitrator received notice of their appointment in writing? It's a conflicting provision in 2 different aspects. And then section 12 says the entire proceeding should be completed in 12 months. 6th schedule also says this, but the act says 18 months for domestic arbitration. That's because in 2015, they implemented this correction or amendment. 2018, they deleted it and they forgot to modify this. So, Limitation Act. I'll not go into all these things. Sir has already touched upon that. But very briefly, how much time do we have for any commercial arbitration? What is the limitation period? 3 years. But the beauty of Arbitration Act is you get total 6 years. Once your dispute occurs, on the last day, you invoke your section 21. That is, you are invoking arbitration. You have 3 more years to appoint your arbitrator. Until that 3 more years, you have limitation. So instead of shortening the time period, the act has actually expanded the time period. So some of the lacunas of the act. What is the conclusion? I am one of the members over there still searching for the answer. With that, I thank you all.
Thank you so much, sir, for providing us an extensive insight into the theme. I now invite CS Chivukula Vasudev, sir, to deliver his address.
Sabhaya Namaha. Good morning to one and all. This is a privilege for me to be there in front of these eminent dignitaries on the dais and off the dais. And a heartfelt thanks to the Institute of Company Secretaries of India, ICSI, and also the Nalsar University for giving this opportunity to share a few of my thoughts. But as you have already seen, the eminents have already spoken. The thoughts, whatever there in my mind. And I could not discuss with them what is the area I should speak before this. So what should I do? What should I do now? So, 1 second, photographer, just come here, stand here. Take group photo of all people sitting. Just smile, please. Smile. Just for the photograph. Come into the middle. Just smile. Smile. Smile, please. Smile. Just smile. Thank you. All the contracts starts like this only. All the contracts, especially commercial, starts like this. Okay. But majority of the contracts ends differently, right? So most of my points I try to touch upon out of my personal experiential learnings and all that. No doubt I should acknowledge that Dr. Bhaskar Mohan, I'm basically one of the students who was taught many of the arbitration issues. And most of the things, whatever you may like out of my a few of the thoughts, also credit goes to him. And also I attended one of the sessions of Dr. Sridhar also. And Pradeep, of course, I'm meeting just now today here. But credit goes to all of them. And before commencing the other aspects, Dr. Mohan sir mentioned that classroom to courtroom, the bridging, whatever is that, the synergy level tremendously. From a corporate side, like corporate rooms also gets added, boards also gets added subsequently. And Sridhar sir mentioning that there are 1 lakh cases in arbitration. And yeah, 1 lakh crores worth of cases are there. Yeah, that is 1 trillion, right? Okay, it gets increasing further, I hope so, by the time mediation really kicks off. Yeah. Now, the point here is, Dr. Sridhar also hails from the infrastructure and construction, is being consultant. I also from the 3 decades experience in infrastructure. So a few points are that mindset he touched upon, very important aspect, and also talk directly with the people and our own concern and try to have some kind of resolution then and there itself. And our Dr. Pradeep also mentioned about the people, about the human element, very, very important aspects. And arbitration is not that much smooth enough. And 2 + 2, the synergy levels also he touched upon. And pro-institutional arbitration and some of the things like common code itself. I thought the discussion between our gentlemen CS, and it will go in a different manner where Dr. Mohan might be required to organize conciliation, mediation, arbitration here itself in this floor, the way it was going on. But anyhow, once the disputes arise, as highlighted by Dr. Pradeep, the parties are no more friends. I fully acknowledge these kind of things. And in yesterday's present, most of you are available, right? Sri Radhakrishna Murthy, who is the advocate and also legal consultant, he mentioned a very important aspect he shared, mitigation of litigation. Mitigation of litigation. Anybody wants to add something else? Come on, all of you are present yesterday also, right? Yeah. Mitigation of litigation is always the best, he says. And since the litigation is always a speculation without knowing the destination. Now, from the litigation side, alternative dispute mechanisms are made available. It's a very, very good platform as such for the industry, especially from the point of the various uncertainties that may emerge in the contracts as such. So the word just will, the word just shall, took about 2 hours discussion in one of the international agreements in Mauritius when I went there. And they were about even calling the advocates, calling the consultants, including comma, full stop, and how do you read, what to read, those kind of clauses pertinent to understand. Because all this emerges because the people are around. The missions won't deal with the contracts. It's the people like all of us deal with the contracts. That shows that
our learnings, our background, our behavioral aspects, our attitude, our knowledge, our skill, our experience, our industrial aptitude towards that, these are the things based on which the interpretations to take place. So the ambiguities may emerge. I may interpret certain things in some manner. The other person may interpret in a different manner. So as we proceed with the contracts, there is a high potential that the disputes do emerge in the commercial arrangements. So in such a case, how do we resolve? And when do we resolve? The timing aspect also. So as long as in the beginning, the contracts, when we are executing, very, very friendly, most of the time, yes, master sort of thing. When certain things crops up slowly, the relationship management and all that comes up. Then typically from the industry of the construction, if you look at the contract modeling, contract structuring also plays a pivotal role. Example, design and build. I design something and I'm not there on the field. When certain things are being executed, there are so many uncertainties that crop up. I do some excavation, I may get some soft rock, I may get some hard rock. And how do you deal? Because my price was given on some other kind of assumption in the beginning. And if you proceed further like that, engineering, procurement, and construction part comes at a later stage. So the design related aspects, the EPC related, and other one is turnkey. What is the key in the word turnkey? Anyone? Yes. you can speak on that for an hour or so. I know, I'm sure. We have 5 minutes more, right? Okay, thank you. Anyone? Because let us participate. This is the third day, and there are no tests after this, my speech. What is the turnkey? Key refers to what? And all of you are aware of that. Yeah. Yeah. Right. Kickoff. Like the moment I constructed this room, this auditorium on turnkey, I just get as a principal employer. From the contractor, I get the key to turn that to operate this building. The moment I come, it should work. The moment somebody dignitaries comes, they should have the seat, nice seat to please, be seated. And the projector should be functioning. And all of you should be comfortable to listen to me, whatever I'm saying. And there should be some kind of facilities. So all these are inbuilt, and this is a turnkey concept comes like that. Now the dilemma comes. In the beginning, it's not possible practically to think each and every aspect, isn't it? Even from the principal employed side, consultant side, also from the contractor side. So the issues crops up gradually like that. So how do we resolve? And this kind of conciliation, this kind of mediation, we do every day at a workplace, even we do at our homes. And the structuring part is brought out through these enactments. That's why this ADR is very beautiful. I appreciate the entire battalion of legal experts about bringing, and also the practitioners. And this is greatly helpful to the industries, especially the contracts industries where the uncertainties are more. In the case of manufacturing, the set process input, processing and output is very clear. The output is known to me. But in case of the EPC contracts, in case of turnkey contracts, I don't know. The principal employer say, why don't this color shading of this that side and this side slightly changing? He may tell that the tiles related to that, there is slight change, the perception levels. So so many things crop up in that kind of design engineering related aspects. So further, if you look at rerouting, design is already part of yours. Why are you rerouting? Come on, you pay for this. If I reroute from this, there is some technical problem, the system won't function. So rerouting is essential. Then you do that because you have done the designing on your own. I have been already factored that. No extra payment for that. So disputes emerge, for example, in this manner, and the change of scope, design related. Employer always feels that the contractor should be taking care of responsibility of each and everything. Contractor feels that whatever the scope initially you thought, as per the invitation to the tendering and all that, to that extent only, let me spend. I don't have provision for that. So the origin of disputes emerge like that. So always the relationship mindset, whatever people mentioned, these are very, very important to tackle these kind of things, because there is a huge incidence and continue to be huge incidence in the entire industries for such kind of potential disputes. Instead of going to the court, the other alternative mechanisms are made available in the form of arbitration, which is literally more formal than compared to the mediation, than compared to the conciliation. We also conciliation, we do many things at our workplaces. And as long as the relations are much, much better, the remedies are very, very easy. I sit along across with the client and move on further according to these kind of things. And the degree of responsibility varies. In the case of arbitration, the decision is by the arbitrators and then that is binding on the parties. In the case of mediation, the facilitation will be done. Like, for example, I arrange and I pick up some of the things and the settlement needs to be agreed upon by both the parties. If they are not agreeing to the settlement proposed in the mediation, there is no kind of settlement. And in the case of conciliation, it is more of relationship building. I enhance good relations, I agree and you agree sort of principles. What are the disagreements that will be minimized? So the facilitation in that process goes. But the last, I wish the industry and the entire businesses should prosper. And of course, since we are human beings, there ought to be some kind of differences do come, but through the process of this ADR, resolving all the disputes amicably with the best relationship and bring the output and take care of various stakeholders, including workers, employees, and be part to the national initiatives, whatever the prosperity this nation is there, and the thrust towards bringing this kind of Indian economy as the global leader in the time to come. And for that, let us also take an acknowledgement based on these Nalsars and as well as ICSI's supportive platforms that we are there to resolve any kind of dispute amicably in the most fair and justified manner across. Thank you for this opportunity. Thank you.
Thank you, Vasudev, sir. After a round of perceptive panel addresses, we now proceed to the scheduled paper presentations for the day.
A couple of instructions for the paper presenters today. Please strictly stick to the time limit of 3 minutes, extendable by 2. After 3 minutes, there will be an indication as to the time. And please wrap up within 30 seconds after the indication. Thank you. The first presenter for today would be Alluri Satyanarayan Raju, sir. I please welcome you to the dais.
Distinguished panel members and my dear co-participants and delegates. And indeed, I am thankful to the ICSA and Nalsar University for giving this opportunity. My paper relates to the Mediation Act, which is enacted very recently. The title I have chosen is Mechanisms of Process of Mediation for Conflict Resolution vis-a-vis Mediation Act 2023. Why we need ADR? Because many spokesperson already highlighted. Before adverting this colonial adjudication process, which is adversarial setup, previously people in olden days, whenever the dispute is there between two people, they ask to fight each other. Whoever wins, he will be the winner of that. Like that, this adversarial setup has become like that. Even whatever the plaintiff says, defendant contradicts everything, even though he can make some admissions. So in this process, time has become victim, and some of the beautiful systems we used to have in the ancient system, this mediation, arbitration, conciliation, were part of our system. Once this colonial system has introduced, all those systems have gone. And even Bhaskar Mohan sir was telling that if a suit is filed and he cannot see what is the result of the dispute, only legal representatives have to be added time to time. And we have 5 crore cases pending adjudication. And if you take this time, it will take another 50 years to dispose of this present backlog, and leaving the filing up the cases, press filing up the cases. This Mediation Act, almost 23 is enacted on the lines of the whatever amendments that are made, and the Arbitration Act from 2015 onwards. And like Arbitration Council of India, Mediation Council also established, and like accreditation of arbitrators, accreditation of mediators also envisaged under this act. However, this act has to be notified by the central government for implementing that. So therefore, now time has become constraint. A full paper I have presented, and one of the significant changes that are made in this Mediation Act 23 is it also introduced community mediation, where the disputes between the communities also can be resolved. And another significant feature is this mediation, unless parties agreed, you cannot advert to mediation. But these tribunals, courts, now under the Mediation Act 23, can sumo to ask the parties to go for mediation. That is included under Schedule 8 of the Act. Time is up. How can complete in 3 minutes? The Act runs into 100 sections. Only for formality, I think they have called, but the time that is given is insufficient. Anyway, thank you for giving me this short time. I will leave.
I now call upon Mr. Adapa V. Subbaraidu sir and Akanksha Mori to present.
Apologies, I make a small request to all learned speakers. The president of NCLT has arrived, also the president of ICSI. I request that you, 2 minutes, you may please just brief all the learned speakers. In fact, even you take 30 minutes is not enough, and we'll be very much, would be enlightened, but I apologize. So kindly accept my apologies. Thank you so much.
Warm greetings to everyone present in the room today. I am Akanksha More. I'm an advocate senior associate at Finlex Law LLP. Since we all know we are running short of time, I'll have to skip through a lot of things. I co-authored a paper with my colleague, Mr. Adapa Venkata Subbaraidu, who is also an advocate. And we have together titled the paper, Data Protection and Privacy in Arbitration, Balancing Transparency and Confidentiality. Since we all know what arbitration is, I would like to come to my main crux, that is how India is understood and has appreciated and the importance and value of data protection. And after many deliberations, we have seen the light of the new legislation that came up in August that is the Digital Personal Data Protection Act of 2023. This act actually recognizes both the rights of the individual to protect their personal data and also the need for them to process such personal data for lawful purposes, which can be of various uses, such as if there is any case of medical emergency, or they have personally given the voluntary acceptance that yes, their personal data can be processed, or even for compliance for judgments and decrees and orders. It is rightly said that change cannot happen just in a snap of fingers. So it is important for us to understand that it is a great initiative, a first step towards understanding that the data needs to be protected, but the privacy cannot actually be contained in a box. We'll have to understand that no right can be protected as 100% as possible. Every protection of the right comes with certain exceptional cases. So, like I said, it takes time. It's not your instant 2-minute Maggi noodles to get cooked in a snap of fingers. It cooks, yes, but it'll definitely take time. This will only happen if there are collective efforts from the government and the individuals in educating and creating awareness in people, along with proper regulation mechanisms to perform at its best. And it will require patience. On that note, I thank everyone for patiently listening to me, and I take a leave from you with a thought for you to ponder upon. Is your personal data really protected? Thank you.
I now call upon Mr. N. Jashwant Rao, sir, to present his paper.
Very good morning to one and all the dignitaries and the panel members. My name is Jashwant Rao, and my topic is about legal impact on ADR functioning and its growth. So, ADR is one of the most important key in reducing the boundless burden of litigation in our courts. While dealing, it's a well-rounded and gives a gratifying experience to the parties involved. It provides expand the pie of collaborative, creative, as well as a fulfillment of interest in demands to the corporate as well as in the legal cases, and directs them to focus on their main business goals rather than reducing their cost and time in the process of conflicts when arised. ADR mechanism comes into play, such as mediation to solve the conflicts between the individual of the corporations or the stakeholders in a company that could help in an effective disposal of litigations. Under Section 89 and Order 10, Rule 1A, 1B, 1C of Civil Procedure Code has included ADR mechanism as a radical step towards the growth and development of ADR in India. As the company is increasingly inclined towards the alternative dispute redressal mechanism and arbitrary institutions such as ICLCIA, SIAC, and ICC. The awareness has been increased among the organizations regarding to the cost of disputing and the potential of saving that has laid down by the various ADR committees such as NIDR, National Institute of Distributors Resolution, which is supported by a large part of cooperative foundations. And according to a research done by GNLU professors, 93% of the advocates are advocating the ADR system, while remaining 7% are refusing it. And roughly 83% of litigants are interested in ADR system to solve their conflicts, where further study shows that young advocates are adopting the ADR mechanism through arbitration, conciliation, as well as mediation. To conclude, the corporate institutions and business organizations are moving towards the process of ADR mechanism, but still has to go far to resolve the corporate disputes, as it has a better impact on the institution, as it takes less expense time than the conventional court procedure. And as we have many techniques in the mediation, conciliation, and arbitration, they have made an encouragement develop in the use of alternatives. It has no longer a system, but it has become a broader in the time course. I thank you one and all for giving this opportunity.
Thank you so much, sir. Now we move on to Miss Nasim Chandni, ma'am.
Yeah. Yeah, yes. Just quickly through. Absolutely. Just go through. Just go through. Yeah. Good morning, everyone. India has entered into 2024 with a bang. According to Global Credit Outlook 2024, released by S&P in December 23, India is set to become the third largest economy by 2030. This has been affirmed even by the RBI in its monetary policy, where it has revised the GDP growth of India to 7% from 6 to 5%. India is aspiring to become the Viksit Bharat by 2047. But with growth comes the opportunities and challenges. So alternative dispute resolution in India in the last few years has transformed like anything. And I'm honored to be here to present my paper here on emerging trends of alternative dispute resolutions in India. The distinct advantages of ADR mechanism has been known to all of us, but recently PwC has conducted one survey where 91% of the companies surveyed in India who have dispute resolution policy has included arbitration and not litigation as their preferred method of justice. And this is because of the distinct advantages of ADR, because ADR is speedier, confidential, flexible, and cost efficient. Now, it's very heartening to know that all the three wings of our constitution, that is legislature, judiciary, and executive, they have supporting the ADR mechanism. Now, different acts of the arbitration since 1940 to then it has evolved in 1996, and three amendments were there, 2015, 19, and 21. These all have been has been done to ensure that expeditious resolutions of the disputes have been done. Now, going ahead, what about the mediation? Chief Justice of India, Sri Chandrachud, has recently said we stand at the dawn of the golden age of mediation. And recently, so many acts has also provided for mediations. Now, going ahead, Mediation Act 2023 has been evolved on, and it has been codified on September 15, 2023. It has again many advantages which has already been discussed. Now even judiciary has been supporting with their various decisions, and that is all are pro arbitrations. No, so even the government initiative is also there, and they are also supporting pro arbitration stand. And going ahead, technology is there, online dispute resolutions, real-time dispute resolutions, and algorithmic dispute resolutions are already there. Ethereum, Cyber Settle, and Click Settle, Smart Settle, all platforms are being used by AI. Now, what is the path forward? I just visualize that ADR and ODR will be there in India. AI will be there more in ODR. Growth of institutional arbitration, I visualized, and India positioning itself as a hub of international arbitrations. As William Gilson has said, the future has already arrived, but it is not evenly distributed. Thank you so much.
Now moving on to Ms. Deepa Raj ma'am and V. Shyam Kishore sir.
A very good morning to one and all present here. At the very outset, let me thank the organizers for giving me this opportunity. Now, moving on to my research paper titled, The Impact of International Commercial Arbitration on International Trade Regime, a Critical Analysis. So as we all know, international commercial arbitration, it is an alternative to the conventional dispute resolving method between two parties residing in two countries. Otherwise, it is a mechanism for resolving the dispute or cross-border disputes arising out of the commercial transactions. So the concept of international commercial arbitration is not new to the traders, because in the early medieval period itself, the traders, they followed the concept of lex mercatoria, which means the merchant law or the mercantile law, as per which it was not a legal system, but it acted as a binding law, as there was no legislation during those ancient days. So what is the main purpose of international trade law? It is to promote free trade among the nation. The free trade means people should be free to buy things and sell things cutting across the national frontiers. A buyer should be able to buy things from anywhere across the world without any barriers. Similarly, a seller should be able to sell his things anywhere in the globe without any barriers. So it is in this context the importance of my research comes. My research paper, it delves deep into the impact of international commercial arbitration on the international trade regime by analyzing the related provisions of the Arbitration Conciliation Act 1996 and several amendments made thereafter, including the Arbitration Conciliation Amendment Act 2015 and the Unilateral Model Law. Though the international commercial arbitration has evolved up to a large extent in the past decades, there exist several lacunas in choosing the laws and also resolving disputes by way of arbitration, as parties to trade are from different nations. So the international commercial arbitration and its legal perspective. Coming to India, in India, we have the Arbitration Conciliation Act 1996. The Section 2 Clause 1 Clause F of the legislation clearly defines what is an international commercial arbitration. And again, this Arbitration Conciliation Act in India, it is based on the Unilateral Model Law. The United Nations Commission on International Trade Law adopted the Unilateral Model Law on commercial arbitration in the year 1985. So I would like to conclude with saying that there are several challenges being faced by the international trade regime, including the high tariffs, customs duties, trade discrimination. At the same time, when we come to the resolving the disputes between the traders, by way of the international commercial arbitration, there are several challenges being faced. Few of these are the enforceability of the awards, the choice of law and jurisdiction, the diversity of the legal systems, etc. I would be suggesting few improvements and suggestions. improving the enforcement mechanism, standardization and harmonization, training and diversity, etc. With this, I conclude. Thank you. Thank you so much.
We now move on to Anush Ishwar and Shreya Aditya for their presentations.
Good morning. I'm Shreya Aditya, and our title of the paper is Analyzing Synergies of International Arbitration in Alternative Energy and Climate Change, Insight into Advancement of the Legal Framework. So climate change is a global environmental challenge, and it doesn't affect the economic growth, but also the development of a country. As time passes, because the global economic system is based on resource extraction, we'll have to move to alternative energy. So elucidating the same, 40% of the cases in the ICC are energy and construction disputes. There's certain international initiatives such as the Kyoto Protocol, the UNFCCC, and the Paris Agreement, which have policies to mitigate climate change as a whole. So before delving into what our international arbitration as a whole is, we want to highlight why this particular niche field and what climate change is as a whole. So climate change disputes are the impact on climate change as a whole particularly, and the disputes arise to aim and mitigate climate change. And the objective of our paper is to analyze international arbitration in this niche field and also understand the limitations and provide feasible recommendations.
Respected panelists, the first step to understand the importance of the functioning of international arbitration is to understand the framework. As the respective panelists have already mentioned, the categorization of institutional and ad hoc arbitration systems, I would like to move on to understanding the approach to which our international arbitrations are employed. So primarily, there are the climate change disputes are responsibilities of nations through international treaties, and the same is carried forward when countries such as various countries employ various measures and policies to mitigate climate change on their personal basis. So it's these responsibilities and obligations which lead to. Okay, I would like to wrap up by just saying that this paper concludes with certain recommendations to the framework of the international arbitration by delving into the transparency and confidentiality fields, and as well as the jurisdiction, and suggesting a standardization of the arbitration clause for the international arbitration institutions. Thank you so much.
Moving on, now we have Melvin Moses and Niharika A to present.
Never cut what can be untied. Greetings to the esteemed panelists and all those who are present here. I, student Melvin Moses
Niharika
of second year law, are here today to present our paper on India's mediation law and prospects of its future. Just like a phoenix bird rising from the ashes, mediation is rising from the blazing furnace of advisory approaches. Mediation as an ever-evolving need due to various factors affecting the dynamic nature of the corporate world. From the ancient wisdom of panchayats to the evolving legal framework, our country has recognized the transformative power of mediation. Mediation is not merely a method of alternate dispute resolution, but rather a philosophy, a way of life that prioritizes empowerment, cooperation, and healing. Its branches reaches towards a bright future, yet its roots are firmly rooted. However, despite of effectiveness, mediation is at a turning point. Though the foundation is laid by Arbitration and the Conciliation Act of 1996, yet awareness is still a barrier and enforcement is too risky. Yet, we need to envision a future driven by mediation rather than only analyze issue. Let us envision a future where discussion and not conflict is a king, where friendly mediators mediate disputes between neighbors over a cup of a tea. Businesses strikes a win-win agreement. Well, this future is not a mirage. This future is within our reach. We need to coordinate actions and agreements as a legal challenges, preventive measures, and tactical breakthroughs. Now, I would like to pass on to my co-author.
Our comprehensive analysis explores the situation of mediation now, its bright future, and the complex web of laws that control it. We have used strong statistical evidence to demonstrate how mediation is becoming a more popular method of resolving disputes. The recent mediation bills, incorporation of corporate organization, mark a dramatic change by enabling companies to use mediation as a tool for dispute settlement. Thus, it should come as naturally that one of the most fascinating recent developments in the field of corporate law and governance is mediation. Before I conclude, I would like to thank Nalsar and ICSI for granting this opportunity on a national platform to all the authors to present and showcase their opinions on the respective topics. Thank you.
Thank you, guys. We now move on to M. Tirupati sir to give their presentation.
Yeah, I don't. Just a few minutes. Fine. Good morning, one and all. Respected chairperson and the panelists. I'm your friends. Is a very less time. I would like to conclude within 2 minutes. My research on alternative dispute resolution mechanism and emerging trend in India. Before going to start my detailed explanation about my topic, I would like to start with a one quote which is said by the former Chief Justice of India, Justice P.N. Bhagwati. The finest hour of the justice is when foes compose their fight through the fair settlement to become friends. With the introduction, ADR is an alternate to the JDR system, which is also known as judicial dispute resolution, which can settle the disputes in a very speed manner. And the origin and history, just now Sir had said that. Then the types of the ADR are arbitration, conciliation, mediation, negotiation, like Lok Adalat and all. Arbitration, conciliation, mediation. Then the mediation is the informal way of the resolving the disputes, where the neutral facilitator called the mediator helps the parties to come to the mutual agreement as a settlements disputes. Negotiation is a technique requires the parties to ready the cooperative setting the disputes in the presence of unbiased third party. Lok Adalat is one of the most effective methods of the ADR, as involves the voluntary actions of the parties of the solving the disputes, is usually conducted in the all days. It is a peaceful and amicable settlements at the Lok Adalat. Section 89 settlements. The goal of introducing the Section 89 of the Code of Civil Procedure 1908 was to encourage the peaceful and cordial as a mutual beneficial resolution between the parties without need for the court intervention. Fine. My suggestions are a mandatory refer to the ADRs, the cases of the civil matters and the family matters, increase the efficiency and build the truth and the quality of infrastructure, and modernize the process of the introduction of the online dispute resolution. I would like to conclude the newly enacted the Act provisions and the policies on the mediation have created a new window in the opportunity of the promoting access to justice for all through reducing the cost and expediting the process of the disputer. Thank you all.
This brings us to an end to this session, this technical session. I thank all the attendees. I also thank the panelists for taking out the time and being here with us today. I now request Dr. Bhaskar Mohan sir to please conclude the session for today. Yes, sir.
Well, my dear friends, really it's a great pleasure, and there's a future India, in fact, very promising and very hope for our country's development. I congratulate them, and then very good presentations. We'll keep it up Sometime later, we'll meet again. The Honorable President of NCLT has arrived. So I think we had to close and then wait for him. So thank you one and all. And we'll hope that there will be very bright future for ADR in India. We'll be the ultimate leader of the world in ADR. Thank you very much.
So much, sir. Yeah, there's one.
The participants are requested to come back for the valedictory session in a while. Thank you.
Good afternoon, everyone. I request everyone to please settle down. By the time we settle down, let me tell you something. Good afternoon again. And I just wanted to say something for 2 minutes. There was one entity called labor laws. He had an issue with an entity called corporate governance, some cybersecurity issue. So labor laws filed a petition against corporate governance with banking and FEMA laws. Now banking and FEMA laws said it is not in our purview. So sorry, we can't take it up. Then they went to SEBI for corporate and securities laws. But simultaneously they felt we should go to IBC because we want the corporate governance entity to be I'll not use wound or close liquidation, but they wanted resolution from there. So they went to IBC. But gradually, as and when the hearing was happening, as and when the submissions were happening, both of them found that there is some issue and it can be resolved together. So they they went ahead, withdrawn the matter from IBC and resolved to ADR, settle the matter. So it only says that all the laws are related. I would like to start the session. Respected dignitaries, members, and students, a very good afternoon and a warm welcome to all of you. I, Padmaja Kalyani, take this honor to welcome all of you to the valedictory ceremony of CorpCon 2024. This is a valedictory ceremony only for CorpCon. Our journey of learning continues. So let's start the ceremony by inviting the dignitaries on the dais. I would like to invite our chief guest, Justice Ramalingam Sudhakar Garu, President, Honorable National Company Law Tribunal, and I would request CS Manish Gupta ji, President of ICSI, to please accompany him. I would like to invite Dr. Sri Krishna Deva Rao, Vice Chancellor of Nalsar, on the dais. I invite CSB Narasimhan, Vice President of ICSI, on the dais. I invite CS Pawan G. Chandak, Council Member, ICSI and Joint Program Director, on the dais. I request CS R. Venkatramana, Council Member, ICSI and Program Director, on the dais. And I invite Dr. K. Vidyulata Reddy, Registrar of Nalsar, on the dais. Let's welcome them with a huge round of applause. I request, let's welcome all of them by expressing our gratitude to them. So I request CS Mahadev Tirunagari to please present a sapling to our Chief Guest, Justice Ramalingam Sudhakar ji. I request CS Lalita Devi ji to present a sapling to CS Manish Gupta ji, President of ICSI. I request CS GSL and Gupta to present a sapling to CS B Narasimhan ji, Vice President of ICSI. I request CS Manjeet Bucha to please present a sapling to Professor Sri Krishna Deva Rao, Vice Chancellor of Nalsar. I request CS A. Karthik to please present a sapling to Professor K. Vidyulata Reddy, Registrar of Nalsar. I request Dr. Keshav Rao to please present a sapling to CS Pawan G. Chanda, Program Joint Director. Please present a sapling to Pawan, sir. I request Dr. Sridhar Rao to please present a sapling to CS Venkatramana, sir. We are honored to have all the dignitaries with us. I request everyone to please rise for the ICSI motto song.
उम्मीद के अंबर में हम बन के खिले जो रोशनी, कह देंगे हम संसार को कोई लक्ष्य नामुमकिन नहीं। ज्ञान के और न्याय के हर राह को थामे हुए चल पड़े हैं झूम कर बस गीत ये गाते हुए। सत्यम वद धर्मम चर, सत्यम वद धर्मम चर, सत्यम वद धर्मम चर। कंपनी सचिव कदमों की हर एक गूंज में बस जीत का एहसास हो, राष्ट्र प्रगति पथ पे हो और आत्मबल की आस हो। जब भी चले इस भाव से खुलते गए हैं रास्ते, आवाज हमने दिल से दी है गीत ये गाते हुए। सत्यम वद धर्मम चर, सत्यम वद धर्मम चर, सत्यम वद धर्मम चर। हर उन्नति के रंग में हर भारतीय हाथ हो, उद्यम हो या उद्योग हो, हर ओर अपना साथ हो। जाना शिखर तक है हमें सच की कलाई थाम कर, हम जीत के सुर छेड़ेंगे गीत ये गाते हुए। सत्यम वद धर्मम चर, सत्यम वद धर्मम चर, सत्यम वद धर्मम चर।
Thank you so much. Also recognize the presence of Shri Badrinath Nandula ji, Honorable Member of NCLT Hyderabad, CS Dr. Punla Bhaskar Mohan ji, and Dr. KVS Sharma Nalsar. We also recognize their presence today. Let's all welcome them. I now request Dr. Sri Krishna Deva Rao, sir, Vice Chancellor of Nalsar, to please give the valedictory remarks. I'm sorry, we also recognize the presence of CS Praveen Soni ji along with us. He's the Central Council member.
Honorable Ramlingam Sudhakar Garu, Chairman, National Company Law Tribunal, Chief Guest of this valedictory session, distinguished guests from the Institute of Company Secretaries of India, delegates, organizing committee members, faculty, staff, students, my colleague Vijulata Reddy, esteemed participants. Good afternoon. It was a great pleasure and profound sense of achievement that I stand before you today to deliver this valedictory remarks for the COP-CON 2024, the National Conference on Development and Trends in Corporate Laws and Governance, a conference which is jointly organized by Nalsar Law University and ICSI. Universities are academic spaces. They're meant to engage, interact, learn from each other. I think in that context, I appreciate our Venkatramana Garu, who took an initiative. We signed an MOU recently, and we said, let's start an academic dialogue and engagement. That's the result of today's conference. This gathering has truly been a celebration of collaboration, knowledge sharing, and collective pursuit of excellence. As we draw the curtains on COP-CON 2024, the inaugural edition of a recurring annual conference, we stand at the culmination of transformative journey that set sail with a grandeur and purpose. This conference marks the commencement of a tradition that promised to be a beacon in the realm of corporate discourse, bringing together visionaries, industry leaders, and experts, and for a yearly redunduous to delve into ever-evolving landscape of corporate excellence. You know, in the NLUs, I think sometimes our senior judges of the Supreme Court and High Courts, they put that one criticism against the birth and evolution of NLUs. Why all your students are going to corporate sector? But I used to say that, no, we also need a good corporate lawyers, good corporate judges, good law firms, good companies. But I think I must admit that's a major attraction. And we are happy and we are proud. I think some of our students in the NLUs are doing extremely well in the corporate lawyering in India and also at the international level. This is hosted jointly by Nalsar University of Law, Institute of Company Secretaries of India. The conference has been a testament to the power of collaboration between academia and industry. The collaboration not only bridged the gap between theoretical insights and practical applications, but also created a dynamic platform where the best minds converge to shape the future of corporate discourse. The inaugural conference witnessed a momentous inauguration by Mr. Praveen Jaipuriar, CEO of Continental Coffee Limited, along with 3 sitting Vice Chancellors of National Law University. That's a really amazing and a pleasant coincidence. We had Vice Chancellor of Mumbai NLU, we have a Vice Chancellor of NLU Jodhpur, and 3 eminent former Vice Chancellors. They were here in the inaugural function. Their esteemed presence added an academic flair to the event, underscoring the commitment of COPCon 2024, fostering a holistic understanding of the corporate landscape. Equally momentous, if not more, is a kick-starting journey into the future by Justice Ramalingam Sudhakar, the Honorable President of the NCLT Delhi. The collaboration between Nalsar University and ICSI has been at the heart of the success of COPCon 2024. It has brought together, as already said, the synergies that has enriched the conference with a diversity of insights and expertise that is unparalleled. As we reflect on the success of COPCon 2024, let it be known that this is not just the conclusion of a conference, but beginning of a tradition, as our friend just now pointed out. May the relationships be formed, the insights shared, and the collaborative spirit witnessed here to continue to inspire and shape the discourse in the years to come. To our distinguished speakers, panelists, and participants, I express my heartfelt appreciation for your invaluable contributions. Your willingness to share your knowledge and engage in meaningful discussions has created a vibrant platform for the exchange of ideas, pushing the boundaries of our understanding of corporate excellence. Just only one idea I wanted to share before I close. Narayana Murthy, I really appreciate who coined the new word compassionate capitalism, which is now expressed in the corporate social responsibility. I would plead all of you in your profession to learn, encourage, and facilitate utilization of CSR grants to education. I'm reminded of a famous quote by our beloved former President of India, late Dr. Abdul Kalam. Learning gives creativity, creativity leads to thinking, thinking leads to knowledge, knowledge makes you great. So this is my request. You must encourage companies. Whenever you are a company secretary, please give to the universities, academia, and other. As we conclude COPCon 2024, I encourage each of you to reflect on the connections made, the knowledge gained, and the collaborative spirit that has permeated every session. The success of this conference is a reflection of the collective dedication and shared vision of Nalsar University, ICSI, and every individual involved in this joint academic collaboration. To the organizing committee, I extend my warmest congratulations on a job exceptionally well done. Your commitment to the success of COPCon 2024 has been truly commendable, and I am proud to witness the impact of your efforts on both the academic and professional communities. Lastly, on behalf of Nalsar University of Law, I extend my deepest gratitude to everyone who has been a part of COPCon 2024. May the lessons learned and the connections made here continue to resonate, contributing to the continued pursuit of excellence in both the legal and corporate realms. Before I conclude, I think generously our chief guest, Justice Ramalingam Sudhakar Garu, has extended for our law students, Nalsar students, for internships in the NCLT Delhi and also NCLT at other. We were also looking up how do we academically partner with the NCLT Hyderabad. and we will look at how our students will learn as a part of our LLM insolvency and bankruptcy course. This is the first course we have started in association with the Ministry of Corporate Affairs. About 50 students have joined. They are doing the first year here. Second year, they will go to Delhi and they will study in the Manesa. Thank you and wish you all continued success in your future endeavors. Thank you.
Thank you so much, sir. This conference has been really first national research conference organized by ICSI and Nalsar. It was really great. So I would request CSR Venkatramanaji, Council Member ICSI and Program Director to please present the conference report.
Thank you very much, Padmaja. Honorable Justice Ramalingam Sudhakar sir, President NCLT, our beloved President Manish Gupta ji, and our beloved Vice President Narasimhan ji, Honorable Vice Chancellor Professor Sri Krishnadeva Rao sir, and my colleagues at the Council, Mr. Pawan Chandak and Mr. Praveen Soni, and Honorable Member, Judicial Member NCLT Badrinath sir, and other dignitaries of Vidyulata Madam and other dignitaries of the dais. Very good afternoon to you all. Friends, taking the mottos of both the institutions of Nalsar and ICSI, Nalsar motto says, Dharme Sarvam Pratishtitam, and our ICSI motto says, Satyam Vada Dharmam Chara. So both the institutions have a common objective of protecting the Dharma and abide by Dharma and also follow the Satya. With this intention, we thought we will have a national conference as we have made it MOU in this year only itself with the Nalsar University, signed by our Vice President Ji, who was there here that day, and Vice Chancellor sir was there. So we had, and we thought we will conduct a first program of the national conference. And I would like to thank Krishnadeva Rao sir, Vice Chancellor, who has immediately accepted the proposal and given us an opportunity to organize at the premises of Nalsar in this beautiful hall. And further, friends, I have to give report of what happened in these 3 days about the conference. So the conference was aimed at bringing legal professionals, legal experts, industry experts, scholars, academia together to exchange ideas, to gain insights into the corporate law and governance. As you are aware, the Nalsar will produce the lawyers, corporate lawyers, and other lawyers, advocates, and Company Secretary Institute produces the company secretaries. Company secretaries are close to the corporate industry, and lawyers are close to the judiciary. So we thought we will get both together to do research on the existing and emerging laws, like labor code is coming up, many other laws. ESG is already there. SEBI regulations regularly changes. RBI, FEMA regulations regularly changes. Keeping this in view, we have coined so many laws which are relevant, even ADR and other laws, on which research has to be done by the research scholars and our company secretaries, and present their papers, their findings to give insights and a thought-provoking questions which arise out of these laws. So based on this, the sessions were conducted. The first session was commenced with deep insights and learnings brought by the guests of honor and the panelists. For all delegates and participants, it was enlightening and brought the corporate culture to our Sark Hall at Nalsar University of Law. Vice Chancellor of Nalsar University, Krishnadeva Rao sir, welcomed the guest of honor and panelists, and the delegates enriched the hall with his experience and wise words. He focused the hard work by quoting Sri Narayan Murthyji's idea of optimum working hours and community dispute resolution. C.S. Pradeep Ramakrishnan, GM of SEBI, shared his experiences with SEBI and how the regulatory authorities have performed outstanding job regulating to capital markets through various regulations. He discussed certain regulations as well. And C.S. Pawan Kumar suggested, one of the panelists suggested that certain compliances under Companies Act vis-a-vis companies, private companies must be relaxed and waived, such as related party transactions, retirement by rotation, loans to directors. On section 2 and 3, the theme of section 2 and 3 was corporate governance in digital age and the insolvency bankruptcy court. Shri Ritesh Kavadia, ED of IBBI, has suggested that IB is not an option. Rather, it is the need of hour. He shared his view on the perfect market, which means the perfect exchange of information, and the company generally do not follow. Consequently, 65% of the companies do not survive. The presenters thereafter addressed the challenges and problems of corporate governance in digital age, focusing on cybersecurity, data privacy, followed by presentations on insolvency, bankruptcy, dealings with concepts like settlement agreements, IBC in combination of ADR, how it functions, revolutionary approach to the global insolvency process. And Shri Honorable Judicial Member NCLT Badrinath has focused on functioning and competence of IBBI in resolving the IBC cases. He suggested that the judges should focus on the legislative intent of the code. He guided the researchers to explore the field of mediation in insolvency proceedings. Advocate Shri Vaisuryanarayana, he addressed on the issues relating to delays, not only caused because of the lesser number of NCLT benches, but also other factors which contributes resource persons at the NCLT, etc. He suggested that various stakeholders should cooperate to serve the purpose of the code. He focused on how technological advancements meet the challenges of the society in the fields of corporate law. Shri P. Narayan Rao Garu from IICA, he focused on the threats regarding technology, boosting market supervision. He also highlighted the concept of CPAC, among others. Overall, this session was informative, engaging. The panelists also emphasized that earlier corporate governance focused on addressing conflict, but after digitalization, structures of the companies and businesses are now in focus. Session 4, the fourth technical session, was on labor laws, Indian Stamp Act and other revenue laws, banking and FEMA insurance laws. This session was enlightened with wise words and knowledge of Sri R.K. Murthy Mudrasar and Mr. Nurul Hassan, and Sri R.K. Sharmaji is from IRDA. It was valuable experiences to engage our panelists with question and answers, and wonderful presentations were made by the presenters. Each area, whether banking law, insurance law, has its specific legislations, regulations. It is also thought that in the banking sector, their regulatory framework should provide independent professionals environment like a bank concurrent audit, forensic audit, and internal audit system should be, robust system should be introduced on that. And based on that, the sessions were concluded. And each area, whether it is banking law, insurance law, every aspect, the role of professionals is immense. And we, the professionals, either lawyers or company secretaries, any other professionals, should play a vital role in building the nation. With this brief note, friends, I conclude my remarks on the conference. Thank you very much. Thank you, one and all.
Thank you very much, sir. It is very true that all the sessions in the last 3 days have been really engaging and very informative, making us to do more research on those topics. I would like CS Pavanji Chandakji, Council Member of ICSI and Joint Program Director, to please address the gathering.
Respected dignitaries on the dais, my dear friends present at this CorpCon 2024. As a program co-director, I am really satisfied with the faces which are emitting the satisfaction of the discussions and the research papers which were presented during the course of last 2 days, 3 days. And the basic purpose of this national conference jointly with Nalsar was to join hands with the academics. We as a corporate governance professionals, company secretaries, our institute is always trying our best, putting our foot forward always for pursuing the great corporates, good corporate governance. Along with that, establishing the standards, not only for the regular matters, but also for the various upcoming and emerging areas in the corporate law and corporate compliances. And I'm happy that this research national conference has really served the purpose which we were looking forward to as a ICSI and as an Nalsar jointly. And I congratulate our president and program director also, CS Venkata Ramanaji, along with our honorable vice president and president ICSI for the extended support for organizing this Nalsar national conference. And with this, I thank each one of you for participating wholeheartedly and making this conference a real success for ICSI and Nalsar. Thank you.
Thank you. Thank you so much, sir. It was, in fact, our pleasure to be a part of this conference. We participants wholly agree to it. Thank you so much, sir. I would now invite our next dignitary. He has over 4 decades of experience. He has over 4 decades of experience in corporate law and management, and he'll be serving as the vice president for the year 2023. He has been the Central Council member for the term 2019 to 22 and served as the chairman of various committees. He's also a member of committees constituted by SEBI and the chairman of Registrar Association of India. So let's request and let's invite CSB Narasimhanji, Vice President of ICSI, to please address the gathering. Please, sir.
Thank you. Chief guest for the day, Justice Ramalingam Sudhakar, President NCLT New Delhi. Guest of honor, Sri Krishna Deva Rao, Vice Chancellor, Nalsar University, my President, CS Manish Gupta, other dignitaries on the dais, off the dais, and my dear delegates. Well, you had 2.5 days of intense discussion on the various topics which was assigned to be covered during this session. I don't have to emphasize the need for all of them. And I think in a validity session, generally a recoup was done in terms of what has been discussed and what was the finite solution which was emerged during the day. I also understand that you have about 60 participants who had given their paper, which is based on which some of the crucial points which can be considered will be presented before the respective authorities. Well, the CorpCon 2024 is on developments and trends in the corporate laws and governance. And I think I would like to have my own small take on that. We have the program had on ADR. I think the need for that need not be emphasized more, because the Honorable Supreme Court Chief Justice is also on record to say that if there are no fresh cases filed, this will take at least to be 20, 50, at least about 60 to 70% of the cases to get resolved. So that is the kind of clogging which is there in the courts, which needs to be unclogged. And therefore, the mediation bill has already been passed. And we expect a lot more push will be given by the corporates. And I look at each one of the company secretaries seated over here to make sure that every contract has a provision relating to arbitration. And this way we will be able to unclog the courts. In fact, many cases Supreme Court is advising, or the high courts are also advising, that it's ideal if you go through a mediation process rather than coming in before and clogging the courts. We also had insolvency. I think one concern which is there is the time frame which is there in the law strictly is not being followed. There are delays beyond that. Somewhere down the line, there is a concern which has been expressed by the people over there, and we need to look at how that can be resolved. Corporate and security laws, I think there is going to be a major change, if I can say so, as far as the security laws are concerned, including corporate laws. As far as the company law is concerned, all the rules, the ministry is looking at having a relook at all the rules with the intention of ease of doing business. And that is a mandate which has already been informed to us by the Secretary MCA, and sooner or later a group would be constituted by MCA to look at what are the changes in the rules which needs to be made to make sure that the business runs on even keel. So we expect a lot of changes coming in over there. And if any of you have any suggestion, please share your thoughts on that in terms of the rule changes which you would like to have with us, with the institute, and we will try to
share it with the group which is constituted. On the securities laws, I'm sure, I don't know, many of you know on this, that there are more than 16 working groups which has been constituted by the chairperson SEBI. And they are going to analyze each and every ICDR and LODR. Apart from that, every single regulation is being looked into with the intention of ease of doing business. You know about Regulation 30, that under LODR was a much debated one. Some of the corporate secretaries were here. Will give a huge sigh of relief when it was said that for the time being, it's going to be kept on hold. So this is there, and there are 16 working groups which has been constituted. And I can tell you, the institute is part of those groups. They are going to look at STD, they are looking at SAST, they are looking at buyback, LODR, SEDR, etc., etc. And the changes which are on the anvil will be benefiting the profession. That much I can say. At this point in time, I cannot share much more than what has been discussed during those meetings which has been held with the regulator. Well, on the corporate laws, the one important item which is taking a lot of precedence over everything else is on ESG, environment, social governance. And you all know that SEBI has mandated about all the 1,000 companies to submit their BRSR report. More importantly, ESG ratings is also going to happen soon. The importance of this, we will soon realize that, because there is what is known as stewardship code. An institutional investor, when he makes an investment, he has to look at what is an ideal company for in which he can make the investment. And that is based on ESG. It's not for the current, but it's for the future. We have to look at what can happen, because the difficulties we are already faced with, we need to mitigate those difficulties, and that can happen only through this exercise. The other topics which has been covered is banking, labor laws. Again, labor laws has been, many states have implemented them, but there are some states still to do it. But I think we are looking at whether we can play a role in the new labor laws which is coming in, and we are seeking recognition from the various state labor law commissioners how PCS can play a role over there. Corporate governance and digital age, I think they are also having significant changes which is coming in. And at this point in time, I think for lack of, I need to mention this. The changes which are there going to come in the LODR will be a great impetus to the profession. That much I can tell you this. And I'm sure once it is released, there will be as a usual practice, the concept paper will be released for public comments. And I want each one of you to share your thoughts. If you feel anything more can be added, share it with the institute, and we will try to put it across to the regulator to have it implemented. Thank you very much. Thanks again, one opportunity for given to me for sharing my thoughts on this. Thank you.
Thank you so much, sir. The ease of doing business has made the companies more diligent, and I believe the day is not far where we will be following all the compliances to the intent and not to the name. Our respected dignitary has been associated with the profession for last 22 years. He was with the council for the term 1922, and he served as chairman for several committees and as vice president of ICSI for the year 22. He's also registered insolvency professional and empaneled as an arbitrator with both BSc and NSC. So let's welcome CS Manish Gupta ji, president of ICSI, and I request him to please address the gathering.
Thank you. Honorable Justice Ramlingam Sudhakarji, President NCLT, Delhi. Professor Shri Krishna Deva Rao ji, Vice Chancellor Nalsar Law University, Vice President ICSI, other dignitaries on the dais, all the participants present here, very good afternoon to all of you. Good afternoon. Let me first thank each one of you for participating in this first ever joint research conference being organized by ICSI and the Nalsar Law University. And this is, let me share with you, this is just a beginning, I would say. And a long way to go for those, both the institutions, both the Nalsar as well as ICSI. And let me assure you that there would be many such research programs to be happen now onwards, because we have taken a lesson from this particular research conclave. All the merits, demerits would be taken care of in the next such national program for the research. And the topics which you people had discussed in last 2.5 days were so much of thought provoking. And I really appreciate your participation. Sir, there are 168 participants in total, and there are 60 plus researchers who have presented their papers in this conference. This is a small beginning, first tiny step which has been taken by the institute, and lot many things have to be done in the days to come in this regard. Sir, we met a few days back, sir. We discussed about the NCLT conclave, which was organized by the ICSI at all the chapters wherein the NCLT benches were also be there. And you had assured us you please complete all those programs at all those benches where the benches are there. And you would be there in one of the last program to be held at Delhi. So, sir, on 13th of January, we are having our last program related to the NCLT on 13th of January at Delhi at the Scope Complex. And that would be focusing on the IBC and RVO, Register Valuer. We have planned it like first national conference for the IBC and the Register Valuer to be held at Delhi on 13th of January only. Sir, on the field of in this particular conference, there are participants from the legal as well as the company secretary side. And I always believe these two professions, legal and the company secretaries, go hand in hand and complement and supplement each other at all the forum, at all the point, and on all the benches of the NCLT, at all the high courts, tribunal, and all, wherever those disputes are there. Because company secretaries and legal professionals are there for the best of the interpretation, as well as for the implementation and for the compliance. And we both, when comes together, there has to be some initial work for the research, which has happened in this conference. So we have started working on the governance front, because we are always being known for the governance norms and the standards being formulated by the ICSI. Up to this time, we are having two standards. One is for the secretarial standards, which is being adopted by the MCA as implemented by all the companies at their respective organizations, as well as the auditing standards, which are there for the company secretaries in practice to follow at the time of the audit. We are in touch with all the governance institutions across the world. There are many institutions and in various countries who are working on the front of ESG as well as on the governance. So we are in touch with all the institutions, and we have constituted a small committee to work upon the sustainability standards. And our institute, ICSI, has taken a lead in it, and very soon we'll be coming out with the international sustainability standards, which would be the benchmark for the ESG compliances, sustainability compliances, BRSR reporting to be done in the days to come by all the corporates. As well as, sir, we do have our curriculum with part of the training curriculum, a CLDP, which is Corporate Learning and Development Program for all the members who are getting the degrees. Before applying for the membership, they have to complete that CLDP of 30 days, wherein 15 days are in online mode and 15 days are in the physical mode. And they have to complete through the residential or the non-residential mode. Both of the options are available as of now. Sir, I have a small request to make. Sir, we do have a topics like art of advocacy in it, moot courts, research, merger amalgamation, IBC. We are taking care of those topics. We are teaching them about those areas of practice in the days to come for them. Sir, can our members, upcoming members, I would say, can come to your benches and have those proceedings, observe those proceedings, see those proceedings, maybe a small batch of 5-10 people at a time at the benches. They can come and sit at the last bench only, just silently observe the proceeding. That will motivate them to come forward and pursue their careers in the NCLT field, because some of the company secretaries are hesitating how those proceedings are going on, how those members are asking the questions. So that would be a good idea to inculcate the habit of having those viewing at the NCLT, as well as they will promote, motivate them to take up those challenges at the NCLT level. So that is a humble request to you, sir. And if you can, I will send a formal representation in this regard. Uh, Apart from this, sir, we have also revised our syllabus last year, and we have captured lot many things which are like future oriented, wherein people are looking for the focusing more on the opportunities of the today's arena, but we are focusing on the opportunities which would be available maybe after 3 years, 4 years, when the student would be moving out of the institute. So we have captured the artificial intelligence, the cyber security. We have captured the arbitration, mediation, and conciliation. We have captured ESG and sustainability as the important topics, along with the merger, acquisitions, IBC, as part of the curriculum. Sir, I'm really happy to share that we have incorporated one Section 8 company, International ADR Centers, ICSI International ADR Centers, wherein we are working on the setup of the ADR centers. And we have decided, the council of the ICSI has decided to set up the ADR centers at Hyderabad, Bangalore, and Noida. Two of such places have already been completed. Very soon we are going to inaugurate those ADRs. And I'm sure the way those work are being taken up by the company secretaries, and the opportunities which are available in the ADR field. It could be arbitration, it could be mediation or conciliation. There are lot many scope which is available for the company secretaries to be taken up in the days to come. So to boost the capacity of our company secretary, we have amended the curriculum of the ICSI, as well as there are so many programs which are ongoing to build the capacity, as well as to make them aware about the provisions and how to deal with the situations relating to ADR and mediation. And sir, we'll also be looking for your support in that regard, because whenever those ADR centers to be set up, so we'll be looking for some of the help from your side, maybe any way, sir. We will come to your office and discuss about those support which can be extended by the NCLT to the ADR center. So that is all from my side. Thank you very much for your participation. And it is really a pleasure that Justice Ramlingam sir is here with us and this afternoon, chairing the valedictory session. A big round of applause for Ramlingam sir. He's always available with the profession. When I met him last time for the purpose of discussion for the NCLT conclave, he suggested the topics. Rather, he amended all the topics. He was like, I am looking for these things to be inculcated in your professionals, company secretaries who are appearing before the NCLT. Don't go by any other topic. I would suggest the topics. And let me tell you, those topics were there in our mail by the evening. And based on the uh, instructions, I would say the suggestions given by Honorable Justice, we amended the entire curriculum of NCLT conclave and had those NCLT conclaves based on the suggestions given by sir only. Thank you very much for all the help and support extended. I would also like to thank Nalsar team led by Professor Rao sir for all the hospitality, for all the support the team has extended for organizing this first ever conference. And this is just a beginning, like we had already discussed about this. And there are a lot many things which we can jointly organize and we can have in the days to come. Thank you very much. Keep on participating, keep on learning new things in life. Thank you. God bless you all.
Thank you very much, sir. It is our pleasure to have you with us here. And as and when Nalsar or ICSI will convene such seminars, we are sure that we'll be a part of it, right? So I would now request Justice Ramalingam Garu to please release the souvenir. I request everyone on the dais for the souvenir release. I request Dr. Badrinath Nandulaji to also be part of the ceremony. Please, sir. Please. Please, sir. Yes, sir. Please, sir. Once. Please, sir. Be insert, sir. Please, sir. Please, sir. Yes. I have been speaking about all our dignitaries. Our next dignitary, he has been the Chief Justice of High Court of Manipur. He has practiced in all branches of law, and his landmark judgment in motor accident claims is implemented all over India. He decided cases regarding enforcement of foreign awards, and he was instrumental in preparing and settling proposals in Budget Proposal Committee. He was also appointed as chairman of High Court Legal Services Committee, and he was appointed as acting Chief Justice of High Court of Jammu and Kashmir in 2018. He is the president of he's the honorable president of National Company Law Tribunal since 2021. It is truthfully our honor to have him with us today, and I request our chief guest, Justice Ramalingam Sudhakar Garu, honorable president of NCLT, to please give the valedictory address. Please, sir.
Good afternoon to all of you. I think last 2 days, you seem to be having a very, big round of sessions. Respected Professor Sri Krishna Deva Rao, Vice Chancellor, Nalsar University, Shri Manish Gupta, President, ICSI, Shri Narasimhan, Vice President, Shri Venkat Ramana, Council Member, Pavan Chandak, Council Member, Ashish Mogan, Secretary, Vidhay Tula Reddy, Registrar of Nalsar University, the dignitaries sitting in this side and on the audience, law students of Nalsar. I think there are quite a number here. Law students of Nalsar are there? I think. Say yes or no? You are there. Law students are there. Because I am also a unfinished law student of Nalsar, so I am part of you. I have still to complete my diploma, which I did not do because of lack of time. Maybe after I demit office, I will come and join again as a student here. I never let my job unfinished. Keep this as a motto. Never let anything unfinished in your life. Complete it. This is one of my mottos. Institution building has always been my forte, and I like that. Law it should come naturally for a lawyer, but you should also be versatile in life. Why I say this is this IBC is a new code. As a student of law, I've seen constitutional law, we studied this, we studied English law, so many things comes, company law, insolvency law. I sat in all jurisdictions as a judge. But first time, let me confess, there is a good law, which is the Insolvency and Bankruptcy Code, coupled with the new Companies Act. Companies Act, of course, it comes from the British system, then it gets modified, it gets amended. But the code is new and fresh, like a morning flower. So what is this code that makes it very, very interesting? Now, in the last 6 years, there are doomsday sayers who keep saying, oh, code, timeline. Just now, Narasimhan was also pointing out that timeline is not happened. What is your big problem? What is this timeline? What is time? Is what we create. Your watch. The impact of code is how sincerely each stakeholder does his job. Timeline is to guide us like a signal. The left side, right side of the road, go like this speed, This is what we call timeline. That is to create efficiency, efficacy. That is why the Honorable Supreme Court said, no, don't put it mandatorily. See, the law is got so many stakeholders. Now, in this audience, you have company secretaries, you have legal researchers, but this is not the full complement of IBC. I am one part, company secretary is another part, lawyers is one part, but there are financial institutions, operation creditors. There are number of people who are part of IBC. And you think in your own house, you can't do it properly. You miss your breakfast, you miss your studies. How difficult it will be for an institution to bring all these people together and pass a resolution. But you'll ask, what happened? I am telling you, IBC is a success. Great success. I'll tell you why. When I joined, people used to say, oh, that IBC haircut, they have passed haircuts just like that, not knowing that haircut is done by the COC, not by the NCLT. Even that they did not know. This newspaper were flashing everywhere. NCLT approves big haircut. We have no role in that. It's the wisdom of the COC. The Supreme Court has said that. But these papers don't know how to write. People just write all sorts of things. COC's wisdom, they have said NCLT has given a haircut. We don't do that. The next one is timeline is bounced. Now, I'll say timeline is bounced in certain cases. For example, if there is a sick person, he will take 6 months or 1 year to get proper treatment and recovery. But if he is just having a cold or a fever or a viral, he will get over in 2 weeks. Now, I'll tell you in that context, what is our effect. In the NCLT, what has happened is that the section 7, I've got a chart here. Yes, mergers and amalgamations from 1/6/2016 when NCLT came until 31/8 of last year, August, is 93%. What is mergers and acquisitions? It's all company secretaries, your role. 93% is done. What is your grievance then? 7% has to be achieved. I'll tell you how to do that. Cases filed under 241, 242, 271, 252, 75, 45Q, or the old 397, 80%. That is from 1/6/2000. I'm not telling about CLB days. Presently from NCLT. Section 7 IBC, disposal, 79.86%. You tell me in any other law where you have gone, so you would get this result? Section 9, 83.72%. Section 10, 93.94%. Admitted filed case. Yesterday, somebody puts a paper, 7,000 corporates are waiting in the queue for NCLT to give. So what is this you are writing? Give me the number, man. I will give you the solution. From informed sources. What? 7,000. Where is the case? There's no case. I know the numbers, what is pending. There is a problem in every case, and that has to be addressed. The role of a lawyer, the role of a company secretary, role of an adjudicator, every player has to make a contribution. Today, NCLT order is like a bread or a cake, or even your local, some famous thing in Hyderabad, let's say, biryani, I don't know. See, so many flavors go into it before it comes out as a finished product. And everybody has to contribute for that. Simply one judge can't pass an order saying, I'm approving this plan. It can't happen. There has to be a company secretary. Now, please understand one more thing which is happening where your role as company secretary is important. A company goes into a sorry state of affairs.
the financial creditors move, they want some results. They want it's become NPA. Now you spoke about Dharma. You are, as a company secretary, wedded to the company. But your code says Dharma. If the company says something which is not in accordance with the law, I'm not even Dharma, according to law, then your Dharma states you correct the company, the board. That is your role. If you do it there, the number of cases which come to NCLT will be reduced. So what is this your role? If you have not done it there, you can't complain, sir, afterwards, I'm going to the hospital. I'm in ICU, the doctor is not treating me, I'm not putting back to life. Array, you had the time to do all these things there. Now, next one. Assuming you come to NCLT, CRP is admitted. What happens? There is a stage where the COC meets and there is an RP. Now, this RP, of course, everybody will say he's a magician, who can do wonderful things, but it's a very difficult job. They have to be, I was telling professor also, you has to be a jack of all trades if you want to be an RP. You have to run a steel company, you have to run a hotel industry, you have to run a housing project. So you have to equip yourself in general knowledge how to deal with this. You just can't be simple 1 to 1 is 2 or A plus B whole square. No, this mathematics will not work. You have to be more than that. Now, having said that, at this stage when the company is going under some sort of distress and the COC, a company secretary can give valuable inputs and guidance to the COC members because the ex-management will also be there. There you play a good role to put the company even back at that stage, give them the correct focus. And what has happened, I'll tell you. That also has shown results. I'll tell you, it is a positive of corporate this thing. The result is, this is how I see that. The case of section 9 and 7, the ex-management with the help of the company secretaries have given some viable solution to the problem. And before it goes into resolution, it has come out of resolution, somehow it has been solved, and this case is withdrawn. Now, who plays a role in that? It's the company secretary. So, if the case gets resolved, then also the role of the company secretary is very important. So, at every stage of a corporate governance, the role of a company secretary is paramount. And you should keep that role as a very, very important thing in the future for the growth of this economy. Now, it is just not the corporate secretary, it is the lawyer, it is the tribunal. So what do we do? The global trade is something like this. Hyderabad, Chennai, Bombay, everywhere there is a link now. It is roads, data, everything is seamlessly transferred. So this trade and commerce increases. If that increases, then the interplay between stakeholders become bigger and larger. Banks, for example. There I have seen banks coming from London giving to a corporate in Haryana or Punjab. So those players, the bank's deposits are by foreign nationals in the banks there. So this is no one, local jurisdiction of Hyderabad or Chennai. It has become a global thing. Now, the World Trade Organization also wants there should be good corporate governance, not only for India, for the entire world. So you have to see the larger picture, what they want. I realized that in the housing sector, Hyderabad is one good place where there's huge constructions going on, development in real estate, like somewhere is Delhi and Mumbai also is going on. But then there is always bound to be some distress. I was just telling the biggest real estate in China, Evergrande or something, it is facing most excruciating, painful insolvency process, and they do not know how to solve. And in India, we solved JP Kensington, one of the biggest real estate in our bench. The judge in China was asking, is there any way I can be helped by you? I said, gave my paper and said, but you know China what it is, they can't express themselves very openly. But this is the truth. So India is doing very well. There is no second thought about it. Now, what is required is something more. That is what I have come to address you. The young students are the future of the corporate law. They have to be trained in good corporate, law process so that timelines are kept. If you ask me, stick to that 170 days, 180 days, 360 days, what will I do? Yes, it is there, but I can't pass an unilateral order. I need the cooperation of the company secretary. I need the cooperation of the bar. I need the cooperation of the suspended board, the RP. So if all of you come with all your inputs, then only we can cook your food. Exactly. So therefore, don't tell NCLT, you are delaying, it is not happening within a time. What can I do? Unless you all come together in the correct form, there will be nothing there. So therefore, making unwanted comments about delays and all that, everybody is responsible for that. That should be taken serious note of. Now, having said that, for ease of doing business, at least now the trend has changed. Now, my call is this. Whether you are a company secretary or a young lawyer or a promising lawyer or a future lawyer, I've requested, Professor, because I don't mean in talking too much, I do only what I want to do, I focus on that. I've already told them, when I told, just now your president was kind enough to tell me, I told them, because this model I have created for all my members. See, I saw this presentation. Alternate dispute, insolvency, bankruptcy court, corporate and security laws, labor laws, Indian stamp, banking, FEMA, insurance laws, corporate governance, and digital age. It looks nice to put so many, but it's very difficult to cover this within 2 days. Whenever I hold a meeting, last month or so, I had it in Chennai. All my members saying, President, we don't have time, we want more time to make our presentation, we want to do more research, we want to have more discussions. There is an hunger for thought process and exchange of ideas. So that is why I told your president, please focus on what it is needed for this corporate law. That is important. Discuss that, give enough time, maybe even 2 hours, but come with some solution. Now, the solution which has come to me in my 2 years of colloquium which I have with my members, because I tried to keep it very small and nice and focused. So once I do that, some brainstorming thoughts come how to do that. One of that, which is like mergers and acquisitions. We are working on a process, what you call artificial intelligence should be used so that first motion gets quickly processed, second motion also we are thinking like that. If that happens, major issues with company secretaries on mergers and acquisition telling, oh, it takes long time to get an order first motion, or yet it did happen. I'm not saying no, it did happen. But I try to keep that numbers within reasonable delays. That is because one factor many people have not highlighted, the 61 judges for NCLT came before IBC came into a law. Madras Bar Association filed a case for company codes, which was converted from company law board. They wanted 61 judges. We are still the same number. Now, if you ask me to carry the burden of IBC, I should also have, if you want to have a cooking for marriage, you always outside caterer. So who is to cater for IBC? Nobody has thought about it. So we are focusing and telling the government, please increase the number. The strength will show the result. All this criticism will go. It's numerical strength that gives you the power to deliver. and we will deliver that. So focus on new articles. And I want youngsters to be part of the learning process in the adjudicating tribunals. I have requested Professor and as well as our president. He is asking about his company secretaries to participate on hearing process. I have already told them, because 1 or 2 sessions, I told we will take classes for them how to address a court, because you can be a company secretary, you can also play. Even RPs, I'm asking them to make a representation. Don't worry whether you have a lawyer. Don't delegate it to a lawyer. You can present your case yourself. But you need that little bit of what you call self-confidence to come into that. Like how a lawyer, first time he asks for an adjournment, pass over. So that's the only thing that junior genius will say, go to the court, ask for a passover. So all that, even that, it starts stammering. And unfortunately for me, the day when I went to as a lawyer, I was told by my office, not by my boss or my senior. A clerk, Munshi, told me, "Arey Baba, this is a case, a civil suit against a housing board. You go and argue the case." First day. And I didn't know anything. I went to the judge. He said, "Come on, today is a mode for argument." So whatever notes was there, I started for 15 minutes and I said, honestly, I'm not prepared. I'm first day in this profession. Then the judge looked at me like this, okay, at least you look tall and nice. Okay, go for come on another day. So the opportunity to present yourself, that should be gained. Unfortunately, digital age, I don't know whether juniors will get that exposure, but you can still come to the courts. Like I have told, the students of Nalsar can go to NCLT Hyderabad, you can go to High Court, see the proceedings there. This is how you get practical knowledge is the best anybody can get. Any amount of book, that will not work. You go practically to court, then you will gain confidence. Many intelligent people, gold medalists, have stammered and faltered before the altar of justice because they are not able to present themselves. They got a gold medal, they can be solicited, they can sit in the office, but when you go to the podium, they are not able to perform. So this should be got out, as you say, let them come to the court and understand that. So now coming to our subject, you had a 2 days CorpCon 2024. I wish that it continues again and again. And there should be one more thing which I need to inform all this our company secretaries is that not only it should be focused, but there should be a takeaway from all these conferences. You should focus and give it to the government, because now, unlike earlier, it was some closed door legislation process. But today we have a regulator, we have the SEBI, as you are saying. They are open to discussion. They are asking all stakeholders. You do not know, before the changes in IBC, the Honorable Prime Minister's office was going on saying, please tell us what is wrong with the existing system, why it is not working. Then only we will amend it. So that is what I like. You ask the people, tell them what you want, what is company secretary feel about this, why this law is not working. Give your informed solution to the problem. Don't say, sir, like a patient going to a doctor, I don't know, I'm not feeling sleepy, I'm not able to sleep, digestion, give me some medicine. You have to show why, what has happened. The doctor asks you, what is happening. So you should give your inputs to the government to give you the best corporate governance. If it is there, everybody will benefit. One wrong concept which was there long time is, you hold on to a case, you hold on to a company, don't let it go. It's not like that. India will grow. You will have 101,001 companies. Foreign investment will come. You will have opportunities. Lawyers, corporate secretary, everybody will have an opportunity. So just go forward, finish a case, go to the next one, finish a company. If you have taken a responsibility for a company, finish that, the next one will automatically come. This, the old system of grabbing onto something, that let go. This is what I'm saying, let go. Things will happen automatically. And I wish you all the very best. It was nice to address you. And all students can please come through your professor and corporate secretaries. They can join for training, because I believe training, and that alone makes positive impact in your life as well as to the country. Jai Hind. Thank you.
Thank you so much, sir. It was our pleasure to listen to you. I guess we should give him a standing ovation, because whatever he said is all his personal experiences. And science says if the backbone of a body is strong, we'll always be fit enough. So if we have such good backbone in ICSI, in CS and law, Justice Ramalingam Garu with us and President of ICSI, when we have such a backbone, that we are bound to grow, and they are creating good opportunities for us. So let us all clap for CS and law again. We would like to felicitate our dignitaries who have taken out the precious time. They have graced this occasion by just with a small memento as a small token of gratitude. So I would be requesting our President Ji to please present a memento to Sri Ramalingam Garu. Please, sir. I request Dr. Sri Krishna Deva Rao ji, sir, to please present a memento to CS Manish ji. I request Dr. Vidyalata ma'am to please present a memento to our Vice President of ICSI, CSB Narasimhanji. I request CSB Narasimhanji to please present a memento to Sri Krishna Deva Rao sir, Vice Chancellor of Nalsar. I request CS Praveen Soniji, Council Member of ICSI, to please present a memento to Dr. Vidyalata ma'am. I request Dr. Charan Tej, Coordinator of CorpCon 24, to please present a memento to our program Joint Director, CS Pavanji. I request Dr. A. Sridhar, Coordinator of CorpCon, to please present a memento to our Program Director, CSR Venkatramana. We would be presenting a memento to our speakers as well, which we couldn't do during the session. So I request CS Pardeep Kumar to please present a memento to Dr. P. Bhaskar Mohan sir. I request CS Nirali to present a memento to Dr. Sridhar Mote, sir. I request CS Manmohan Sharma to please present a memento to Dr. to Sarvareddy Pradeep Reddy, sir. I request Ms. Mahima Sharma to please present a memento to CS Chivukula Vasudev, sir. The valedictory ceremony, thank you everyone. The valedictory ceremony would be incomplete without thanking each and every person who has contributed to the success of this conference for the last 3 years. So I would be requesting Dr. K. Vidyulata Reddy ma'am, Registrar of Nalsar, to present the vote of thanks.
So good afternoon to one and all. I definitely believe the last speaker for the 2.5-day marathon conference, I can understand the patience you have to hear from me the vote of thanks. So I won't stand between you and your lunch for a long time, but as a host, I have the job to, it's honor for me to present the vote of thanks to the dignitaries and to the panelists and to the paper presenters and the organizers. And first and foremost, I would like to thank our chief guest, Justice Ramalingam Sudhakar Garu, for coming all the way from Delhi. And we can understand, all of us know that many of the NCLTs only have members and there is only one president. So besides the judicial work, he is also the administrative head of all the NCLTs in India. You can imagine how busy he must be and what is the kind of time he has taken out for this conference and come all over to attend this. We sincerely thank you, sir. Thank you very much for taking out this time and coming all over. And we will be very, very happy to have associated with Company Secretary Institute, the ICSI, and the kind of enthusiasm they have shown, the cooperation. And this conference would not have been happened but for their cooperation in every level and at every stage. So I would like to thank the President, CS Manish Gupta Garu, Vice President, Mr. Narsimhan Garu, Council Member and Program Director, Sri Venkatramana Garu, Council Member and Program Co-Director, Sri Pawan Chandak Garu, and Secretary Ashish Mohan Garu from the Company Secretary Institute for associating with Nalsar and for organizing this conference. I truly believe conferences are the biggest intellectual stimulators and they provide the path for legal changes, administrative changes, or you name anything. Because all the panelists and presenters will prepare for a month, structure their thoughts, present it in 10 minutes before a intellectual gathering. So they take all that their hunger or whatever we call it as the intellectual thing, the ideas that they want to discuss. So that's the best place to have the idea exchange. And somehow the conference culture has really deteriorated across India and in universities. It is becoming very difficult to organize a very good conference these days, and more especially post-COVID. So in spite of this, the organizing committee has done a tremendous job, I would like to say. And my definite congratulations to the team of organizers, especially under the guidance of Professor Kesharao Garu and our young colleagues Sridhar and Charantej, and also from the ICSI side, Mr. Sharma and Kaushik. So they have really toiled to make it a success, because I would like to tell you why we should thank the organizers very much. You just imagine a conference where, can you believe that the participants we have from SEBI, we have from NCLT, we have from IBBI, we have from ED, we have from IRDAI, we have from IICA, we have from Law Firm Partners, and we have from Indian Council of Arbitration. I think amazing, this level of participants. From the NCLT, we have members themselves, Bhaskar Mohan, Gupta, and Badrinath presenting, and 5 vice chancellors of NLUs addressing the gathering at one, maybe it inaugural, maybe at valedictory, or maybe as a chairperson of a session. Sharma sir was chairing a session. So we had 5 NLU vice chancellors attending this conference. And we have from Insolvency and Bankruptcy Board, Ritesh, from ED, Benjamin Chettiar, from IRDA, R.K. Sharma, and from Indian Council of Arbitration, Sridhar, from Lakshmi Kumaran Partners, so, and from IICA, Narayan Rao. So we have some 7 regulators or in a way major authorities participating, vice chancellors, and being the chairing the sessions. This is one of the best gathering, I would say. And I hope all of you will take that fond memories with you when you go. And I hope you enjoyed participating at Nalsar. And if you don't like some food, maybe sambar or idli, tell me, write the feedback. I'm happy to take it. Enjoy. Thank you. Thank you all for coming. Thank you, all of you. Please join us for lunch.
Thank you so much, ma'am. Ma'am, the food was really good here. Thank you, ma'am. It was our pleasure. In fact, I cannot use words because it was really nice to participate in the 2.5 days or 3 days seminar. We would also like to thank CS Praveen Soni ji, who has contributed to this, to organizing this conference. And a special thank you to Mr. Srinivas and other MC members of Hyderabad chapter. So they would be CS Mahadev sir, CS Lalita Devi ma'am, chairperson of Hyderabad chapter, CS GSLN Gupta, CS Manjeet Bucha sir, CS A Karthik, all the MC members and all the organizing committee of Nalsar. A special thank you to everyone. Special thank you to all the sponsors as well who have really shown interest in this conference. Continental Coffee, Oro Reality, Hetero, Ramki, Lakshmi Kumaran and Sridharan Attorneys, Mailan and Kalamandir. And I would not be justified or it would not be correct on my part if I do not thank one who is very special to this conference, are the participants. A very big thank you to all the participants who have been here for the last 2.5 days, who have gained knowledge, but without whom this conference would have not been a big success. So again, a big round of applause for all of us. I would request everyone. Before, I'm so sorry. I would request everyone to please rise for the national anthem. Small important announcements. I request everyone to please collect the souvenirs from the registration desk. It will be given there. And second thing is, entire conference has been uploaded in YouTube channel of Nalsar. which has thousands of viewers. So if anyone, obviously everyone would like to see the presentations again, so you can do it in the YouTube channel of Nalsar. Thank you and happy learning.